procedurally and substantively unreasonable. First is the failure to consider the defense counsel's non-frivolous arguments. The second is the failure to provide reasonable explanations consistent with 3553A. And the third is the reliance on improperly calculated guidelines. One of the issues that's raised by the defense that was not addressed by the judge implicates both the procedural and the substantive reasonableness arguments. I referred in my brief to the case in the Second Circuit case of Dorvey, which describes the inherent problems with the child pornography guidelines, in that they routinely result in sentences or sentencing guideline ranges that are at or near the statutory maximum. And I would assert that based on this, sentencing judges have an obligation in every child pornography case or sex offender case to address with great particularity the 3553A factors. And again, regarding disparate sentences, the judge did not address this issue at all in her sentencing. I'd ask the court to consider several of the Fourth Circuit cases that are not cited in my brief, but are available to the Fourth Circuit as precedent in terms of reasonable sentences for cases such as Mr. Lester's. There must be many more cases, but my search turned up two which are very similar to Mr. Lester, in that there were defendants who pled guilty to one count of producing child pornography under 2251A. Those cases are U.S. versus Rivas, 575 Appendix 104, in which the defendant pled guilty to one count of child pornography under 2251A and received a sentence of 180 months, the mandatory minimum sentence. And in the case of U.S. versus Silva, 643 Federal Appendix 306, similarly, the defendant pled guilty to one count of production of child pornography and received a sentence of 262 months. And again, this is in contrast to Mr. Lester, who received a sentence of 360 months for a guilty plea to one count. There are some cases of under 2251A that I found in which I think Mr. Lester clearly received an excessive sentence in comparison. One of those is U.S. versus Blauvelt, 638.
You know, if you're going to go through and start comparing one case with another, it's difficult to generalize and just say somebody pled guilty to a statutory provision and received a different sentence. We have a sentencing range created by the guidelines, and we have factors that feed into it. And in this particular case, there were quite a few factors that contributed to the district court's 30-year sentence. I mean, including actual molestation and touching of the child, and including pictures of bondage, and a large number of images. And so if you're going to be trying to compare sentences, you're going to have to try to get the facts much closer to even start with the argument. But
yes, I understand, Your Honor, and I appreciate that perspective. It's difficult to find the specific elements in these cases that match up exactly. There are two cases.
I understand that.
Yeah.
I understand that. Yeah. But I mean, what we have is we have a guidelines range specified, which is presumed to be an appropriate sentence. It's been pre-established by a lot of statistics and studies and findings. And within that guideline range, the district court exercises discretion. Now, in this case, there were a lot of different facts that characterized this particular violation. And my reading of what troubled the district court were those factors is what troubled the court and moved the court to the sentence it gave.
Yes, respectfully, Your Honor, there were many factors that were not addressed. As I was saying, the defense counsel raised many factors, including disparate sentence, that were not addressed by the judge. And I recognize that the judge relied on other factors, but from the reading of the record, it appears that she relied in terms of 3553A almost exclusively on the need to protect the public from the defendant. In her sentencing, when she imposed sentence, there was reference, I didn't see reference to any other factors in terms of 3553A. She did, as you noted, rely heavily on certain facts that troubled her about the case, and particularly the fact that there was touching of a victim, there were sadistic images, and that the defendant admitted taking photos of teenagers in a mall. But, Your Honor, those factors were all addressed within the guidelines. And again, there is a problem with the guidelines calculation in this case, and I'd like to address that briefly, given your response regarding the other factors. The guidelines calculation that was made was 2 levels higher than was appropriate. It was a plain error, and the government has conceded, I believe, that this was plain error, and has asked the court to exercise its discretion not to correct the error based on the totality of the circumstances. I would urge—
Is it plain error here, counsel? In this particular case, the defendant said it's a concededly correct guidelines range. He said so in both orally and in pleadings. The judge relied on that and did not require the government to put on further evidence. This is a case where there's a single sentence in a statement, in an uncontested portion of the statement, where the child's mother mentions something, but that's contrary to all the other evidence on which the court relied. Why is this plain error?
Because, Your Honor, if all the facts are considered within this within the transcript that we have before us, it appears uncontradicted that at the time the offense occurred, Mr. Lester was not the step-uncle of this child. There's no evidence that says he was at the time. He was the step-uncle at the time of sentencing, and everybody agreed upon that. But based on the guidelines, the enhancement should only occur if he was a relative at the time of the incident. And for that reason,
But that is in the pre-sentence report, and it's uncontested at the time of sentencing. In fact, it's explicitly stated to be uncontested at the time of sentencing.
It was uncontested that he is the step-uncle, Your Honor. That's correct. But again, at the time of sentencing, that was his status. At the time of the offense, that was, as I read it,
position.
yeah.
I understand the position now, but why should the district court why is it plain error for the district court to rely on a record wherein defense counsel who's had a full opportunity to talk to his client doesn't contest it at the time of sentencing? And that's the enhancement depends on it being true at the time of the offense.
Yes, Your Honor, that's why it was not, that's why we're using the plain error standard here, because it was not identified at the time. And this certainly is not the sentencing judge's fault. Nobody identified it at the time. It was just an error that was made based on a mistake. It was a mistake that was made at the time.
Ms. Olivia, I have 2 things I'd like to ask you about. The first is, don't the sentencing guidelines instruct courts to view these categories broadly? And so strictly speaking, whether his brother was married to his partner before she became his wife, you're talking about the context of the domestic relationship, aren't you? And it seems to me that the sentencing guidelines quite arguably provides that latitude for that this really shouldn't even be considered error that needs reversal. And then the second thing I want to ask you is concerning the court's failure to address age and likelihood of recidivism. Do you plan to address our case of United States versus Webb, the case that came out during the summer in July on that issue? So if you could take those 2 questions, it would be helpful.
Okay, thank you, Your Honor. The first question regarding the broad interpretation of the enhancement, or the language regarding the relationship between the defendant and the victim. I believe that was intended regarding the caretaker role, in terms of anyone who is in a caretaker role doesn't have to be officially designated as a caretaker. That was my interpretation of the reading regarding the broadness of that particular guideline. I don't believe that the word relative was meant to be interpreted in any way other than relative, but
I thought the guideline itself talks about anybody who is in the care, custody, or supervisory control. It starts by saying parent, relative, or legal guardian.
Yes.
And then it says, or if the minor was otherwise in the custody, care, or supervisory control. That's pretty broad, isn't it?
Yes, Your Honor, I agree that's very broad. But again, because everyone had assumed that the word relative covered the situation.
I'm not saying relative. I'm not asking you about relative. I'm asking you about the disjunctive in the custody, care, or supervisory control of the defendant.
Yes, and
he was there with the child in the bedroom in the house. He was living in the house, wasn't he?
That's my understanding, but Your Honor, there was no inquiry really as to what the setup was in that house, and so that's why I'm arguing that at this point there's no basis to presume or infer, even in a broad construction, that he had control in terms of a caretaker role over the child. It appeared that he was just living in the house, not as a caretaker, but just as a place to stay, which apparently he did later with his mother in the time prior to his arrest in this case, that he was just staying.
What about the evidence in the case, though, Ms. Halevi, that he was alone with the child? So certainly we know at least during the period he was alone with the child, he was in some sort of a caretaker role, wasn't he?
Not that wouldn't be my interpretation, Your Honor. I suppose one could speculate that might have been the case, but I would submit that it's more likely that because the child was asleep when this occurred, that it was in the nighttime when she was sound asleep and he was not authorized to be in her room. That was my interpretation, but it's, again,
no, that's a good point. But given the ambiguity in the record, how does this amount to plain error?
Well, again, Your Honor, I respectfully submit that this particular situation is not one in which there's any evidence that Mr. Lester was a caretaker for this young child. And so
caretaker is not the only thing. It's caretaker or custody or supervisory control. I mean, he's the only one at home. She's 3 years old. He's the only adult. He's got to be in the supervisory control at that moment.
Again, Your Honor, I understand your interpretation and I respect that.
Not interpretation of the facts. I mean, tell me what his role was if a fire starts, or if she needs to go to the bathroom, or if, in other words, there's all kinds of conditions that arise that he would attend to. I don't know. He's not there. He obviously was there as the babysitter, so to speak.
Your Honor, my interpretation was very different in just based on the facts of what we received, was that he was living in the home and that he was not authorized to go into the child's room. It was at nighttime when the parents were both, not the parents, the mother was home with my client's brother, and that they were home at the time, and he went without authorization into her room. That was my interpretation based on the evidence that was submitted. Again,
Ms. Halevi, I don't mean to cut you off there, but it seems to me that you're under a minute here now.
Right.
And the most helpful case for your position is United States versus Webb regarding the court's failure to address the age of the defendant. Do you intend to address that here today?
Your Honor, I would rely on that case. I did not plan to address it in detail, and I don't believe I'll have time in the 30 seconds I have remaining, but I do believe that it's relevant.
Why don't you consider addressing it on rebuttal then, if you would.
Okay, thank you. Thank you, Your Honor, I will. In terms of the age, just as a general matter, Your Honor, there are other cases as well that require the courts or suggest that the courts, as part of the analysis for an appropriate sentence, consider the age in terms of what age the defendant will be upon release. And I think in this case, he's 46 years old now, and a 30-year sentence will render him in his 70s at the time of release, which is a very old age. And I'm out of time, but thank you for the opportunity to address that.
Thank you. Mr. Watkins?
May it please the court, Your Honor. The government is asking this court to affirm the district judge's sentence in this case, as it was procedurally reasonable as well as in substance. First, Your Honor, I'd like to address the procedural matter. I believe my colleague has raised a number of issues that she does not believe the district court properly analyzed the 3553A factors and arguments for a variance. Judge, when you read this record in its totality, I think nothing could be further from the truth. We have a district judge that is engaged, that has a back and forth with family members about not only his age issue, but their love for him, his employment status, having worked for a fire department and done some good service in his working years. The judge specifically acknowledged reading the motion for variance that Mr. Veith made regarding the guidelines and alleged problems with enhancements that some of the literature has pointed out. She told him it was very well written. At the end, after hearing from the mother of the child and everyone else, this judge takes a break and says, I need to step off the bench and let me contemplate these things before I pass sentence. This is an example of what I think this court wants to see from their district judges, a careful analysis, considered reflection on the arguments made by counsel, and exchange with the witnesses called in mitigation, and then a recitation of the 3553A factors. And this judge, yes, ma'am.
Mr. Watkins, I agree with you that the district court addressed many things. What concerns me in this case, though, is the court's failure to address his age-related argument, and the length of time that he served or would be required to serve, and that he didn't need a sentence above the minimum because of he would not be likely to recidivate, if that's a verb. And it seems to me that United States versus Webb, which we decided on July 13th, 2020, is exactly the same case, in the sense that in Webb, at no point in hearing did the court engage the counsel on a discussion of the defendant's age and his lower future risk of recidivism. And we said, the government is asking us to do what we've said we cannot do, fill in the gaps in the district court sentencing. Now, don't we have a gap here regarding the defendant's age argument? I don't see anything in the record regarding the risk of recidivism and the defendant's age. I agreed with you that the judge was very comprehensive in other aspects, but don't we have a Webb problem here? And if not, why not?
Yes, ma'am. Your Honor, I would direct you to page 120 of the joint appendix, where the family, they're addressing the court, and this is his mom, and is raising the issue that even 15 years, that is going to be an extended sentence for him, and she might not live to see him get out. And the court acknowledges this, and I'm sorry for you, ma'am. I know it's tough, and recognizes that. And I think under Lynn and Rita, that is sufficient, that the context and circumstances, Your Honor, shows that this district judge listened to that argument and heard that argument. And Judge, I agree with you that, of course, your Blue decision, as well as Rita from the Supreme Court, requires a district judge to consider arguments for a variance. But I don't think it requires, when you have the context and circumstances like this, for a judge to essentially tick off each argument. Like, for example, in Rita with the Supreme Court, there were 3 arguments made for a variance: the gentleman's military service, his vulnerability in prison, his physical condition. The district judge really didn't specifically address any of that. In the Rita case, the judge said he was unable
Right,
to...
but I'm concerned about whether Webb binds us here. I understand your position that the district court was sympathetic to everybody involved, was thorough in most respects, but I'm worried about the panel in the Webb case pretty clearly said that a failure to address an argument related to a defendant's age and lowered future risk of recidivism is a gap that the appellate court cannot fill in. And this is, let me see if I can get you a page site, but the site to Webb is 965 F 3rd 262. And that's, excuse me, that's at page 271 of the Webb opinion. How do we get around that?
Judge, I believe you look at the context and circumstances as the Lynn case, which came after the Carter line of cases and dealt with the procedural reasonableness of sentences and the failure to explain aspect of procedural reasonableness. And we look at this, we look at the age issue was raised here and the colloquy with the family members. It's clear the judge listened to that and understood it, but it's also clear that the other 3553A factors, such as his dangerousness to the community, outweighed that. And I think that's clear by the context. I understand if you disagree with me there, but I think the context and Lynn specifically would allow you to do that, and you would not be filling a gap. We would just be following what the record says and what Lynn allows us to do.
Okay, thank you.
Let me ask you this. I thought somewhere in the record, Lester talked about fearing that he would die in prison and he wouldn't see his family again. And the court responded saying, I hear all of you, include all the folks, including him, before taking a recess, expressly stating, I've heard your arguments. Isn't that all the Supreme Court requires, is that there be expression that the matter was considered?
Judge Niemeyer, I agree with you, and you're absolutely correct. Mr. Lester himself raised that, and under Rita, I think the judge clearly heard that. There's no question that she listened and took a break.
Well, she said she did. She expressly said she did.
Yes, sir, I agree. I agree with you completely. I think that Rita, in light of this record, should settle the matter that there's no gap to fill. And Your Honors, as to substantive reasonableness, could a reasonable jurist have given this sentence in light of the egregious facts? Absolutely. And judges, you know that if you three were trial judges and this case came before you, there might very well be 3 different sentences, and there could be very well 3 reasonable sentences. And is 30 years a significant sentence? Yes, it is. Is it substantively reasonable? Yes, it is, with hands-on contact, photos of the hands-on contact of a young child, the predatory activity in shopping malls, taking pictures of young girls, a large child pornography collection on top of this, bondage images. All this, Your Honors, supports a sentence. Again, could a reasonable sentence on the gamut have been lower? Maybe, probably, but certainly I don't think we can say that this judge erred in substance in passing sentence here. Your Honors, as to the plain error issue there, the government in its brief agreed with counsel that there was an error insofar as the probation office, it seems, specifically indicated it was applying the enhancement because he was a step-uncle. Crystal, the mother of the child, says they weren't married at the time on the record, and a good lawyer had found that statement and raised an argument. The government believes it doesn't matter, Judge, that you should not recognize that error. It doesn't jump off the page, and I think you can raise, I will be honest with you, I toyed with the idea of not accepting it was plain error at all because the guidelines are so broad and the categories as we've talked about. However, you know, sometimes the government can be criticized for not conceding where it ought to, so perhaps I gave away a bit too much in light of that. But nonetheless, there's no reason to recognize it. Judge Keenan, yes, ma'am.
Okay, Mr. Watkins, I want to get back to that language in Webb because this is still troubling me. I know you keep citing Rita, but Webb is the law the Fourth Circuit here decided just a couple months ago. And it says we cannot infer from the requisite consideration, we can't infer the requisite consideration from silence alone, no matter how attentive. And where is there evidence here that the court addressed his argument regarding his age? I don't see, can you point us to any place in the record where the court talked about the defendant's age and how that would impact the sentence that the court was giving him? Because I just don't see it here.
Well, Your Honor, in addition to what I've already pointed out, of course, the judge adopted the findings of the pre-sentence report, which set out his current age and indicate that she obviously knew how old he would be when he got out of prison if he lived through his sentence, whether he got a 15-year sentence or a 30, as well as I think there is no question that she listened to his arguments, acknowledged having heard from him, and took a break. And Judge, despite, to the extent one would want to read Webb strictly and say that what this judge did was improper, I think we would be elevating Webb over Rita and what Rita requires of a sentencing judge. In this case, Rita is clear that the judge did not tick through each of the three variance arguments, but it was clear from the record that this was a straightforward, conceptually simple arguments. And while the judge could have said more, he didn't have to apply a guideline sentence. This gentleman, though it was a significant sentence, got a guideline sentence. And as your honors know, a sentence within the guidelines, less of an explanation than perhaps a variance upward or downward is required. And I think with Rita, Judge Hendricks, or the district judge in this case, certainly satisfied that. So your honors, I'm happy to answer any more questions on any of these matters. If there's nothing, I will stand on my brief.
What about the 3553 statement at the end that this is principally based on incapacitation, that 360 months is necessary to protect the public, and that's the basis for the judge's finding? Is that sufficient?
Your Honor, I think that is probably the key 3553A factor and reason that she gave him such a lengthy sentence, but I don't think it was alone. I mean, obviously, I
understand that part. I think there's a lot in this record, but isn't the judge's statement that that's what's necessary to protect the public, that 360 months is necessary to protect the public? Isn't that sufficient under 3553 to explain the length of the sentence?
Yes, sir. That's essentially what the judge said in Rita. He couldn't find a reason why the guideline sentence didn't apply, and he needed to protect the public. Supreme Court said that's sufficient. That's essentially a mirror image of what we have here. So, yes, sir. Well, if there's nothing else, Your Honors, I'll stand on my brief, but again, happy to answer any questions.
All right. Thank you, Mr. Watkins. Mrs. Halevi?
Thank you, Your Honor. I don't know that there's more I can say regarding the Webb case than what Judge Keenan has already expressed. I do agree that that requires a judge to address the issue of age, and I don't believe that it is precluded.
Well, let me ask you about this word
Yes.
address. It seems to me you rest heavily on that.
Yes.
We in Slappy, we indicated that a sentence that the judge needed to address non-frivolous arguments. Right after Slappy came out, the Supreme Court came out and reiterated Rita and said that all the court needs to do is ask to demonstrate that it considered it. It used the word consider. So then the very next case after that, Judge Gregory was again writing in Ross, and he said, consider or address the matter. And so whenever we say address, since that Supreme Court case, which is only about 1.5 years old or 2 years old, every time we say address, we obviously have to mean address in the sense that the court has to show that it considered it but not need to express words. And I think that's still the standing of Rita and every Supreme Court case that's addressed sentencing. So in this case, after the defendant, both the mother and the defendant talked about age, he was worried he was going to die in prison. He wouldn't see his family again. His mother said the same thing. She said, I hear this and I'm going to take it into consideration. And she then took a break. But it seemed to me there's zero doubt that she considered these things. It was part of the dialogue. This wasn't just silence. She was listening and she acknowledged she listened. And so I don't understand why we can't defer to the discretion which the trial judge has to select a sentence based on incapacitating a defendant in a very, very dangerous situation. The court found the man dangerous and rely on that, having considered everything else. We're getting to the point where we're almost scripting what a district judge has to say rather than getting to the substance of we have to know enough to decide whether the court erred. But we do know enough. We know everything the court heard and considered in this case, and we can weigh that, and the court expressed itself quite thoroughly. This is a very extensive exchange that engaged here. And if this is error, I'm not sure what we are going to require sentencing.
Well, Your Honor, I respectfully disagree. In my reading of the transcript, the judge often responded by saying, I hear you, or I know, and then she took a recess to consider, but it's very unclear what, in my reading, in what she actually was considering, because
well,
she never
they had just spoken it to her. They had just spoken it to her.
But there were a lot of things that were spoken, and she took a recess and didn't put anything on the record other than the need to protect the public. And I agree with you that she clearly intended to incapacitate this defendant. But again, one of the cases I wanted to cite in contrast was U.S. versus Blauvelt, 638 F. 3rd 1281, in which there were this is a case in which someone went to trial and was convicted of 5 counts of child pornography production, and received only a 293-month sentence. And so in comparison, when you look at disparate sentencing, this is something, again, I know the court hasn't taken this up at this oral argument, but I would urge the court to consider that factor as well as a 3553A factor that is relevant in this case, as well as the age factor, because there, again, in my reading, the judge said she would generally consider all the things that had been said, but she didn't specifically say, when I go back, I'm going to consider A, B, C. She didn't specifically
Well, she said
indicate.
the last substantive thing she heard was Lester talking about his dying in prison and not being able to see the family. There's a brief exchange, and then the court says, this is really a tough case. The defendant, I don't really understand because he appears to be highly intelligent, capable, working on behalf of law enforcement kind of one way or another. He seems to genuinely love his family, which is how she took all the age issues. And they seem to, despite everything, genuinely love him and forgive him. So it's really a hard situation. So she is now reflecting on all this statement, which is mostly related to age, not being able to see him again, dying in prison. My family had cancer. I will probably get cancer. These things are said, and then this is her response. Now, I don't quite know how we're supposed to read dialogue.
Well, again, Your Honor, I would just, if I could just respond that the response of the judge appeared to me to be a very general response after quite a lengthy presentation by defense counsel of all of.
So you want her to insert in there, I considered his age, I considered the cancer, I considered the fact he won't see anybody, and then go on? Is that what you want to add, instead of her saying, I hear all these things, it's a tough case, and I know everybody loves him and cares for him? I mean,
Your Honor, again,
we're in a real world where people are trying to do their best, and this judge was very conscientious, spent a lot of time listening, empathizing with everybody, including the defendant, and addressed the reasons why she thought, despite that, we needed a heavy sentence, and she explained that too. I mean,
Again,
what
Your Honor,
more are we to review? Was that abuse of discretion what she did?
well, again, Your Honor, in terms of a sentence that is sufficient but not greater than necessary, she imposed all of the standard requirements for sex offenders plus some in her supervised release terms. And there was no indication of why those particular conditions would not be sufficient to ensure the public safety rather than an extended prison term. And that I think is an important element of what needs to happen at any sentencing, and particularly under the child sex offender guidelines, where again, almost a very large percentage of people who are facing these guidelines are facing the maximum allowable under the statute.
Yeah, but that doesn't take into account that he had 2,200 pictures. He had 6 bondage pictures. He touched the defendant. He photographed, the victim. He photographed the victim. He photographed others in a public situation where they didn't know about. These are all facts that make this more egregious in the district court's eyes.
I understand, Your Honor. I recognize also that I've run over my time, and I'm happy to address this issue further if you'll allow, but I don't want to.
All right, we'll get you. Well, you have some rebuttal. We'll have you back. Let's. No, this is your rebuttal, isn't it?
This is the end. So I appreciate the time, and again, my plea is that the court consider all of the defense counsel's arguments that were not addressed, and that the blanket statement given by the judge in our position is not sufficient to address the issues in any meaningful way. I understand address or consider, but it doesn't appear that those were considered when you look at the sentence itself.
All right. Well, do I understand you're court appointed?
Yes, Your Honor.
I want to thank you, genuinely thank you for your service to the court. You've done a fine job, and of course that's a very important service that attorneys perform. I also would like to indicate that it's our custom and practice now to come off the bench and come down and shake each of your hands. This is part of the Fourth Circuit practice that's gone since the 1930s, and it's sacred. And unfortunately, this is probably the first time that I know of that we've not been able to do it. But when you come back to court again, we're going to shake your hands double-wise to make up for this one, and we'll do this one virtually and greet you. Thank you for your arguments. We'll adjourn take a short recess to reconstitute the panel with the new counsel. Thank you very much.
Thank you, Your Honor.
This honorable court will The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, welcome. We have Mr. Kamens. Do you hear me?
Yes, Your Honor.
And Ms. Cole, do you hear me?
I do, Your Honor.
Okay, we're ready to proceed in the case of United States versus Ayon Brito. And Mr. Kamens, we'll hear from you first.
Good afternoon, and may it please the court. Mr. Ayon Brito was charged with violating 8 U.S.C. 1326 by being found in this country after previously being deported. To be found in the context of 1326 means, as this court held in United States versus Uribe Rios in a decision written by Judge Duncan, that federal immigration authorities learned of his identity and illegal presence in the United States. In this case, the government charged that Mr. Ayon Brito was found in Cumberland County, Pennsylvania, but it brought this case in the Eastern District of Virginia. Because the violation of the statute occurred in Pennsylvania, the district court erred in denying the motion to dismiss. In a criminal case, venue must be narrowly construed. And the first step in determining the appropriate venue is identifying whether there is a specific venue statute. In this case, there is. It is at 8 U.S.C. 1329, and it provides that venue for this offense is where the 1326 violation occurs. Therefore, as this court said in Uribe Rios, Section 1329 places venue for a Section 1326 violation in any district where the alien is found. That means that venue for the charged offense is the Middle District of Pennsylvania, not the Eastern District of Virginia. In other words, the crime charged here is not presence within the United States unlawfully. The offense is being found when federal officials found Mr. Ayon Brito in Pennsylvania. The government argues that venue is proper in Virginia because it says a found in violation of 1326 is a continuing offense. There are at least two basic problems with this argument. First, venue in this case is determined by the specific venue provision at 8 U.S.C. 1329, not by the general venue provision at 18 U.S.C. 3237.
Well, why do you say that? Those are not distinct. It seems to me 1329 says where the offense occurred. Where the offense occurred is where the elements of the crime were committed, right? And one of the elements is found. And the word found has been interpreted by most courts to be a continuing notion, but maybe that's not the best word, but it means encountered, identified, and recognized as illegal. That's what Judge Sykes nicely said in the Seventh Circuit, but we have also repeated it in a little different form. And he was first encountered in Virginia, and then he was identified in Pennsylvania and recognized as an illegal alien in Pennsylvania. So it seems to me the act of finding involved Virginia and Pennsylvania, but that's where the offense occurred because found is one of the elements. So I don't see that 1329, which uses the word occurred, and 3237, which talks about where it was started in one place and completed in another. It can be in any district.
So just to be clear, Judge Niemeyer, 1329 says that venue is appropriate where the violation occurs.
That's what I'm saying, and a violation occurs when the elements are satisfied of the crime, right?
All of the elements, that's correct.
All of the elements, one of which is to be found in the United States.
That's right, that's when the violation occurs, and so the violation...
Actually, I disagree with that, though, counsel. I don't think the violation occurs at any point between entry and apprehension, right? And so the violation occurs at any point between then. What we said is a continuing offense, and the offense ends once the person is apprehended or is identified by law enforcement, both as being a person and being illegal, and that's when the statute of limitations starts to run. But it doesn't mean that the offense is not a continuing offense at a begins at the point of entry and ends at the point of apprehension, and actually can be apprehension plus.
So with respect, Judge Myers, the statute, the found-in statute, is not violated until the defendant is found. That is, and if an individual comes into the United States without authorization and they were previously deported, the found-in portion of the statute has not been violated. And let me give you an example. So let's say an individual has been previously deported. If I could just provide my example.
I'm listening.
All right. If a person has been previously deported, they come back into the country and they live for 10 years without being found in this country in Vermont. And then they decide they'd like to move to Canada. And then they attempt to leave the country. They get stopped by Canadian authorities. They're never found in the United States until the Canadians turn them back and bring them to the US border. In that case, there is no found-in violation. And the reason is... Yes, Judge Keenan.
I'm sorry, Mr. Camus, I didn't mean to interrupt you there, but it seems to me that you're equating found with apprehended. And it would appear that the venue statute is referring here to any place in the United States at which the violation may occur or where the person is apprehended. So it seems to me that the statutory language is very, very precise. Any place in the United States where either the violation occurs or the person's apprehended. So it could be any one of a number of places once the illegal entry has occurred, couldn't it?
No, and just to be clear, the second portion of the statute where it says that an individual where the case can be brought wherever an individual is apprehended, the Ninth Circuit has said that it's unconstitutional, and the OLC has issued an opinion that says it's unconstitutional, and here's why. If an individual comes into the country, enters the country unlawfully, and then, and the government knows that, they learn that this person is here unlawfully and identify them, and then they're apprehended in another district. The offense, the entry offense, occurred at the place of entry, and even though the statute says that the person can be prosecuted at the place of apprehension, if that doesn't relate to the commission of the crime, then it violates the Constitution. That part of the venue statute is not at issue here. The only question is whether the defendant can be prosecuted in the Eastern District of Virginia when they were not found. When you suggest that we're confusing or conflating found with apprehended, we're suggesting that the word found, the violation of 1326, that specifies a found-in violation, has a specific meaning. It's the one that this court determined.
What is the rationale behind your argument? It seems to me that there's a lack of logic in the fact that a person can only be can only be prosecuted where they are found and apprehended, according to you. Because if a person moves around in the United States in 5 different places, just the fortuitous circumstance of ultimately being apprehended makes the difference when they're in the country illegally the whole time?
No, and just to be clear, there's usually only one place that a person is found, and it means when federal immigration authorities identify the person and recognize their presence here. So usually, even if a person moves around to 5 different places, it is the place where federal immigration authorities find them and recognize their presence here as being unlawful. That is the sole place where they can be prosecuted. And let me explain the rationale behind that. The venue statute generally, or the constitutional provision on venue, requires that venue be limited to the place where the offense occurs. That can be complicated. So the first element of this offense is deportation. And so, for example, if you look at the elements of the offense, potentially, and you consider that venue is anywhere where the elements occur, then the government could conceivably transfer every illegal reentry defendant to the border where that individual is deported. And they know in every case where a defendant has been deported because they have to get that in the context of the prosecution. And the problem in the context of venue is that it allows the government to decide where an individual may be prosecuted. And immigration is one context where there is vast difference between the way that the government prosecutes 1326 prosecutions throughout the country. In some places there are fast-tracked limitations on punishment. In other places there are not. And so the rule that we are suggesting is a very simple one, and it is the one that is required by 1329, and that is that a found-in prosecution is only allowed in one place, and that is where the individual is found. In Uribe Rio,
why does that not read that last? You're reading that last clause as pure surplusage with that reading.
The last
It's
clause of
or
1329.
where there may be apprehended. Any place or.
No, I'm reading that as unconstitutional, as the Ninth Circuit and as the OLC have said. And the reason is, for example, if someone is prosecuted for entering the country after a prior deportation in Texas, but the person is apprehended in Arizona, the Ninth Circuit and the OLC, the Office of Legal Counsel, have said the offense that the person is charged with is entry into the United States after a prior deportation. That has to be done where the person entered the country. It can't be done somewhere else in the country if that's what they're charged with. The same logic applies to a found-in violation. If someone is found in the country, that is where they have to be prosecuted for a 1326 violation.
So it's not a continuing violation.
I don't think it is. I don't think the court needs to reach that.
I think we have to.
Well,
If you want us to rule the way you want us to rule, we have to say that this court was wrong in Barnett when it said a deported person who succeeds in re-entering the country without detection is in violation of 1326 everywhere he goes. Venue is thus proper in any of the places he goes. It's unpublished, but it's an opinion from this circuit. Is that just wrong?
I do believe it's wrong. I believe it's obviously unpublished and so therefore isn't binding precedent. Let me explain why I think it's wrong. The reason is that 1329 doesn't require the court to decide whether this is a continuing offense or not. It simply requires the court to determine that venue is limited to the place of the violation. In this case, the violation, the found-in violation charged in the indictment, is Pennsylvania. If you agree,
but I think Judge Meyer's question is the venue is determined by where the offense occurs. If the offense is committed in any place where the person goes and is continuing in that sense, that's where it occurs. So, and he can be prosecuted there. That's the question, I believe. You can answer that, but I think it is necessary to make that decision.
So let me be clear, Judge Niemeyer. In a case, in a world where there is no specific venue statute, you're absolutely right. What the court has to do.
Well, this statute uses the word occurs, where the offense occurs. That's the venue statute of 1329.
Well,
and the question has to then be, where does the offense occur?
It's
right.
And I don't mean to quibble with you in terms of the language, but there is a difference between offense and violation.
No, it says occur.
Right, it says violation.
The violation, where the violation occurs.
And understood, but Your Honor, the found-in violation hasn't occurred until the defendant is found. So an offense may begin, it may have a middle and it may have an end, but a violation only happens when the elements are satisfied. And so that's why I'm not trying to play semantic games with you, but I think there is a difference between when a violation of a statute occurs and when an offense may occur. Because an offense, to the extent that a part of the offense occurs in one place and a part of the offense occurs in another place, it's different than a violation of the statute. Until Mr. Ion Brito was found, that portion of the statute had not been violated. And so back to my hypothetical, which actually comes from a Second Circuit case, if a defendant lives in the United States, is present, has been here unlawfully, they're charged with being found in the country just because they were present. In the case that I'm referring to, the person left the United States and then was only found at the border when the Canadians turned them back. That is not a violation of the found-in portion of the statute. They cannot be prosecuted based upon being found in the country because they weren't. Their mere presence was not enough. And so it's also important to keep in mind that if someone enters the country unlawfully, that is where the violation occurs of entry. And so an individual who enters the country unlawfully after previously being deported has to be prosecuted in that place of entry. It's not like that offense of entry continues. There's no continuation after they have entered. If the government wants to prosecute them for entering the country after a prior deportation, they are limited to the place of entry. And the same logic applies in the context of a found-in violation.
Can you give us specific citations for what cases you rely on to establish that as a necessary element?
So that is that found is a necessary element of the offense?
Yes, that is that in this circuit, it's when the person is found and the offense is not complete. Illegal reentry by the aliens not complete is not a continuing offense up to the point where they're arrested.
Okay, well, the most apposite Fourth Circuit decision is United States versus Uribe Rios, and that is 558 F. 3rd 347, Fourth Circuit 2009. And let me just briefly describe the facts. In that case, the defendant was apprehended by state authorities in the Eastern District of North Carolina. They received a 6-year sentence, and then they were ultimately transferred to a prison in the Western District of North Carolina. At that point, ICE identified that person, and a 1326 prosecution was brought. And the defendant said, wait a minute, I was found back in the Eastern District of North Carolina. The state prosecuted me there. They knew my full identity. There was an ICE detainer that was lodged, although under a different name. And this court said, no, the found-in violation occurred when the federal immigration authorities identified that person, their identity, and their illegal presence. And that occurred in the Western District.
But,
and so,
yeah, I've read the case. It doesn't say that the violation was not continuing up to that point. This is a question about when the statute of limitations begins to run.
well,
It's either not a continuing violation or it is.
So I don't think it is, but even if it were, I think that we should prevail. And I'll give you an example. The 11th Circuit, for example, considers it to be a continuing violation. That is 1326 in the context of statute of limitations. In the case, the most recent case that we cited, Jimenez from the Middle District of Florida, it's the exact same circumstance, and the government made the exact same arguments. This is a continuing offense. It's subject to the general venue provision in 3237, and the district court said, it doesn't matter. 3237 certainly asks or says that courts can, that defendants can be prosecuted wherever an offense begins, continues, or concludes, but that's not what 1329 says. 1329, the specific venue provision, says that prosecution must occur in the place where the violation occurs. Of course, it also says we're apprehended, but again, we're not dealing with that portion of the specific venue.
I understand, but a continuing violation occurs in all those districts.
It can, but a continuing violation, if I can answer, only matters for purposes of the general venue statute 3237. If we're right, that venue is determined by the specific venue provision and not the general one, it doesn't matter whether it's continuing or not, because the violation, that is the violation of the statute, the consummation of all of the elements hasn't occurred until the defendant is found.
Okay, Mr. Kamens, is your argument weakened though to any degree when you look at section 1329 and it refers to the prosecution may be brought at any place in the United States in which the violation may occur, as opposed to the place in the United States? It seems to me that perhaps your reading of the statute would be taken care of if the language had been the place in the United States, but Congress chose to use any. Doesn't that make a difference?
It could, but there are 3 places that the statute says that people can be prosecuted. That is where they attempt to enter, where they enter, and where they're found. And so conceivably, if the government knows where a person has entered after a prior deportation, and they know where a person is found, the government can choose which venue that they'd like if they're different. So they could choose to prosecute the person for being found in where they're found or where they entered. I don't think it in any way diminishes our argument that venue in this case is determined by 1329. In this case, they have charged that he was found. And in this case, the indictment says he was found not in the Eastern District of Virginia, but in the Middle District of Pennsylvania.
All right, thank you.
Thank you, Your Honor.
We'll hear from Ms. Call.
May it please the court. Good afternoon. I want to start off where we left off a moment ago, talking about this circuit's opinion in Uribe Rios, because I think it needs clarification on the meaning of the term found. Now, the meaning of the term venue is present only where a defendant is found and did not consider whether venue would be proper anywhere else. Later on in that exact same opinion, the Fourth Circuit clarified the meaning of the term found when it cited United States versus Gordon, which is a Seventh Circuit case. And it said there, to be found in the United States means to be present in the United States without permission after deportation. It continued that the immigration agency's discovery of the alien is not an element of the offense. So I believe the language there and the understanding of this court's prior ruling helps clarify the meaning of the term found, and that's exactly what the government's position is here, that found simply means present, which means that the violation occurs really anywhere that the defendant is present after illegally re-entering the United States and up until the offense completes. I'll note, however, as I believe Judge Myers pointed out, in De Leon Ramirez, which is a more recent opinion of this circuit, the court did note that is an open question in the Fourth Circuit when the offense completes. So as some circuit courts have found, the offense may complete when the defendant is discovered by federal immigration officials. However, other courts have mused that it may be when the defendant is apprehended for the immigration offense, or even when he departs the country. Now, briefly to touch on another point that was made about the term apprehension, I believe it was said that this was not an issue here. There are a number of ways that this court can find venue proper in the Eastern District of Virginia under either of the applicable venue statutes. And one of those is the provision of 1329 that allows for venue where an alien is apprehended. Now, the Ninth Circuit opinion and the OLC that my friend Mr. Kamen cited, I believe state that this may be unconstitutional to the extent that they provide for venue where the violation or the offense was not committed. And that is simply not the case here. The defendant was apprehended in Virginia to the extent that that is where federal officials first took him into custody. And similarly, the offense occurred in Virginia because of his presence there prior to his arrest in Pennsylvania. Now, after touching on those points, I do want to talk about a couple of the takeaways from
Let me ask you on that question. Do you read found to include the notion that there has to be an apprehension, or can a person be found in the United States but not apprehended? In other words, let's say the local sheriff calls the immigration people and said, we had a guy staying here at the motel who had been deported and was now back here in the United States on an illegal status. He checked out last night and headed for Montana. Now, is that found, or do you need apprehension to be found?
I don't believe you need apprehension to be found, Your Honor. I mean, in any case, it's hard to think of a time where a defendant is charged without also having been apprehended at some point. But to be found...
Well, no, he'd be apprehended first and then charged. He'd be apprehended on the probable cause that he committed a crime. And the crime in this case was based on the sheriff's report that ABC checked out of the hotel and he was a person who had violated 1326. But he left this morning in a car going west to Montana. And the immigration officers are told about that. This is in Pennsylvania. And he's told about that. Is he found at that point, or is he found when they finally apprehend him on the way to Montana?
It's the government's position here that he would be found in that case, yes. And that's under the meaning that I just described.
Both in Pennsylvania and Montana? Would he be found in both places?
To the extent that the defendant was present in both locations, yes, which I believe is what it was in the hypothetical. And that's essentially the language I just quoted in Uribe Rios, which comes from Gordon, that says to be found means to be present in. Now, turning to kind of the extensions of these rules that are being articulated, first off, there's a bit of a peculiarity that venue could be at issue in a case like this. The Supreme Court has expounded on the values and the public policy considerations that are protected by constitutional and statutory venue protections. And chief among those is that a defendant not be brought to a faraway place for prosecution of a crime. In Coors, the Supreme Court said that the provision for trial in the vicinity of the crime is a safeguard against the unfairness and hardship involved when an accused is prosecuted in a remote place. Provided that the language permits, the act in question should be given that construction which will respect such considerations. Now, a rule that a violation of 1326 is a point in time offense, so not a continuing offense, essentially insists that in a number of cases, including this one, a defendant be taken away from where he is for the majority of the time that the offense is being committed to a faraway place. Now, the construction which the government supports, that it is a continuing offense, is really, on the other hand, a defendant-friendly rule. And there's 4 reasons I'll point to. First off is that it would allow prosecution in the district where the defendant is residing during the commission of the offense. Second, it provides a defendant with more limited criminal exposure. So thinking of the offense as beginning at a defendant's reentry and completing sometime, whether it be his discovery by federal immigration officials or later, is simply one offense. However, if you think of it as a point in time offense, it exposes a defendant to multiple units of prosecution, including the entry, perhaps an attempted entry, and however many times he may found, at least in the defendant's argument, found by federal immigration officials. So
why does he have to be found? Why does he have to be found by federal immigration officials? What if the local sheriff finds him and calls the officials and they arrest him someplace where they can find him? But that he's first is recognized, encountered, discovered, identified by a local sheriff. Has he violated the statute?
Yes, and exactly, Your Honor. I meant to premise what I just said was in the defendant's argument found by immigration officials, but in ours it would be found anywhere by anyone. And I would agree that he violates the statute if he's found by a local sheriff. Now, third, on this same point, regardless of the multiple permissive venues that may be allowable under this rule, the defendant will always have the ability to move to transfer venue for convenience, and that simply did not happen here. So there's a number of safeguards here that perfect defendants' interests in these prosecutions. Now, I'll focus for a bit on continuing offenses and what those are, because I think that is important to the decision here, as a couple of Your Honors have noted, and makes the venue determination quite easy. And I'll be brief in describing the test, but I think the Seventh Circuit articulated it pretty clearly in United States versus Orona Ibarra, which was a 1326 case dealing with a venue issue. And it said, to determine if Congress created a continuing or multi-district offense, courts consult the specific venue statute, if there is one, and the nature of the crime alleged, and the location of the act or acts constituting it. And there the circuit is citing court. It goes on to say, if Congress is found to have created a continuing offense, the locality of the crime shall extend over the whole area through which the force of the offender operates. Now, when we look at the statute at issue here, 8 U.S.C. 1326, it's a logical consequence of the language that Congress envisioned a continuing offense. The gravamen of the offense is essentially a defendant's presence in the United States following deportation or removal, and the continuation of that presence. Now, every circuit to have considered the issue, at least in the context of a defendant with a surreptitious entry of whether this is a continuing offense, has found in the affirmative. And this interpretation gives meaning to the statutory language that we've pointed out that says a defendant who enters, attempts to enter, or is at any time found in the United States. The court in Uribe Rios, as I said earlier, favorably cited a decision of one of these courts, Gordon, in saying that the defendant is to be found means to be present. And that's in line with published opinions, or sorry, let me move on. Moving on in Barnett, this circuit specifically found that venue would be proper in such a continuing offense as a 1326 anywhere the defendant goes. And although that is an unpublished decision of this circuit, it's in line with the published decisions of the 7th and 9th circuits in Rodriguez and Ruelas-Arreguin. And I'll briefly overview, since this was touched on a bit earlier, the applicable venue statutes. And the statutes here, which are 8 U.S.C. 1329 and 18 U.S.C. 1337, work in harmony. But looking at the text of them, there are at least 4 ways which this court can find venue permitted under the statute, or under these statutes. The first I'll go to is one the defendant touched on for a moment, which is the venue in any place where a violation occurs. And the meaning of the violation, the word violation or violation occurs here, can really be read in context against this backdrop of law finding that an illegal reentry offense is a continuing one. And this circuit in Barnett specifically said that the violation occurs anywhere that a defendant is. So that's the first. The second would be the point apprehended, which I believe I've already touched on, but I'm happy to go into more. The next is turning to 18 U.S.C. 1332-37, which is not in conflict with 1329 here, based on the points I just said, has 2 more provisions that make clear the applicability of the continuing offense doctrine to this crime. The first is simply the general statement that venue for a continuing offense is proper anywhere that the defense begins, continues, or completes. Here, it is not in dispute that defendant was in Virginia prior to his arrest in Pennsylvania, and that is simply where the offense continued. The offense began where the defendant entered, and it completed at some point later, which is at the earliest when he was in Pennsylvania and arrested. Now, turning to the next paragraph of 3237, there's one more provision that's applicable, which provides for venue for in cases involving the importation of a person, and it provides for venue anywhere such imported person moves. And this is a broad provision. This court has advocated for the broad interpretation of the word involving in this statute, and this court's opinion in Brittweiser works in favor of that. In that case, and I'll briefly describe the facts, but in a limited detail, it involved a sexual assault on an airplane that was in interstate commerce. And this provision of 3237 not only applies to offenses involving the importation of person, but also offenses that occur on transportation in interstate commerce. And the court in that decision found that it was not necessary to find precisely where the plane was, where the offense occurred, because it was covered by this statute. And that allowed for prosecution anywhere that this means of transportation in interstate commerce moved, anywhere from the takeoff to the plane to the landing. And that's exactly the case in cases involving importation as well. And regarding whether this applies in the first place, I want to note the statute in Brittweiser didn't use the word involving means of transportation in interstate commerce. It's not simply necessary that the statute have specific language used in 3237 in it. So it is not necessary that 1326 either has the word importation. It is clearly an offense that involves the importation of a person, albeit it be self-importation at many times. But that in that respect, 3237, the second paragraph also applies. So these I've kind of outlined 4 ways that the applicable venue statutes apply, and any of them can be read either alone or in tandem to allow for venue here. The last thing I'll note is simply the perhaps lack of precision in some case law regarding this term found. And I touched on it a bit in Uribe Rios, and how some law in the venue realm has basically assumed, without holding, that venue is proper, perhaps only where a defendant is found. But moving outside of the venue context, the word found has appeared a lot in the context of the statute of limitations. And what's happened there is there's apparent discomfort with the courts of perpetual liability for a defendant facing 1326 exposure, and they've sought for an act that triggers the statute of limitations. Now, for other continuing offenses, that may be for a conspiracy, a withdrawal, or the capture of the individual, or for an escape, the return of that person to prison if it's an escape from prison. And in looking for that triggering event, courts here have landed in a number of circuits on this discovery by federal immigration officials. And it's the government's contention that's really the only relevance of the discovery for this offense. It's not an element of the offense, and it's not relevant to venue. So what has happened is a number of these circuits, in dictating what the triggering event for statute of limitations is, have stated that it is where they are found by federal immigration officials. So there's some confusion or some imprecision in the opinions that use this term found solely in the context referring to discovery of federal immigration officials, but it's solely in determining a triggering event for the statute of limitations. Now, the only other point I want to make, and it's very brief, is looking at the language of the two applicable venue statutes here, 8 U.S.C. 1329 and 18 U.S.C. 3237. I do want to note that they are both drafted permissively. They both use the term venue may be based in such and such district. Neither of them are couched in the word shall or anything that shows that they are exclusive in nature. So, absent a confliction between the statutes, which there isn't, really either can apply. So this court's decision can really base its opinion on either statute.
Is that it?
That is. I will rest on my brief. Thank you very much.
All right. Thank you, Ms. Call. Mr. Kamens?
Your Honor, 5 brief points. To start, I believe my friend said that an individual can be found even by a local sheriff completely apart from whether federal immigration authorities find or know that an individual is here unlawfully. And that's just directly contrary to what the court held in Uribe Rios. That decision.
Well, it is. And the discussion there is in a context, but it seems to me there's nothing in the statute that says the federal crime element found has to be found by anybody, particular person. I would think that if a private citizen found a person in the United States who had been deported and reported it, that person is found at that point. There's a violation occurs where the person is found. It didn't say found by federal officials. And I don't know how you can add that element when Congress didn't put it there.
Well, that's the holding of Uribe Rios. And
I understand what that case says, and it's a discussion about that because it's focusing on the discovery aspect for purposes of prosecution. It's a federal crime, and only the federal prosecutors can prosecute it.
The defendant challenged statute of limitations in Uribe Rios, and it also challenged venue. In that case, the defendant said that venue should have been in the Eastern District of North Carolina. And what the court held, and I'll read from it, it's on page 357.
Well, I'm familiar with that, Mr. Kamens. My question to you is, forget that because that is a contextual discussion. Tell me where we find the requirement that the finding be done by a federal agent of any kind. Well, tell me, look at the statute. That's the statute.
I understand what the statute means.
And you agree it doesn't provide any such thing, right?
It doesn't say federal immigration officials. That is what
it doesn't say anybody. It doesn't say anybody.
And that's certainly true, but courts have rejected around the country defendants' arguments who say, actually, I was found when I was arrested by that sheriff in Texas. And even though the federal immigration officials didn't know about it, the statute of limitations started when that sheriff arrested me. And now you're trying to prosecute me later.
Well, that can be answered. That can be answered by what the Seventh Circuit did. Judge Sykes said the word found includes 3 components. One is encounter. Second is identification. And third is recognition of the illegal status. Once those 3 things are satisfied, you're found. Now, if the sheriff encounters somebody and it's identified, it seems to me the only question is when it's first recognized that his illegal status. If that's recognized, that person, for purposes at least of that holding, would be found, and the statute would be satisfied.
Well, unless it's by federal immigration officials, I would disagree with the court. If I can make 2 quick points, or actually 3 quick points. May I?
I don't know if you can make three. Make your best point. You're over time now.
There may be line drawing issues about the definition of found, but that's not an issue in this case. The indictment charges that the defendant was found in Pennsylvania. It doesn't say.
Well, it says, no, it's not quite fair. The indictment says he was found in Pennsylvania, but was first encountered in Virginia.
True. It doesn't say
Okay.
he was found in Virginia.
Yeah.
Secondly, there are two elements of a found in offense: deportation and being found without lawful authority. Neither of those things, based on this indictment, occurred in Virginia.
Okay.
If I could say the last thing, the government says there's no qualification on the venue statutes. You look at the first words of 3237, it says except as otherwise provided by Congress, and the first words of 1329, which say notwithstanding any other law. And
Of course, that presumes that they're intention, but the government's position is that they're not intention. 1329 says where the crime occurs, and 3237 says if the crime occurs in different places, it can be brought at any place. Those aren't inconsistent.
The rule is if there's a specific venue statute, we determine venue by the specific statute, not the general.
Well, that's not a general. That's just how to construe a situation where the crime is committed in different districts. The 1329 says it's where it occurs. And then 3237 says if it occurs in different districts, it can be brought in any of them.
I'll
That's
conclude.
just any district.
Yeah, that's not intention. Well, anyway, I think we understand your positions, and we'll take these all into consideration. We normally come down at this point and shake hands with counsel. That's been our long-standing tradition. It's the symbol of the Fourth Circuit and of our views of the relationship between the bench and the bar, and we're so sorry we can't come down and do it today, but we'll extend our handshakes to you virtually now by greeting you and welcoming you and thanking you for your good arguments.
Thank you.
In light of that, we'll stand adjourned to take a recess in order to reconstitute the court. Thank you very much.
Thank you.
Thank you, Your Honor.
This honorable court will take a brief recess. United States Court of Appeals for the Fourth Circuit.
All right, thank you. Mr. Byrne, can you hear me?
Yes, Your Honor, I can.
Mr. Adams, can you hear me?
Yes, Your Honor, I can.
Okay, we'll begin with the case of United States versus Wilson. And Mr. Byrne, we'll hear from you first.
Thank you, Your Honor, and may it please the court. My name is Jonathan Byrne. I'm appearing this afternoon on behalf of the defendant in this case, Justin Wilson. There's no dispute that Mr. Wilson brandished a firearm when he stole a pickup truck from two individuals. It's also undisputed that that firearm was unloaded. As a result, Mr. Wilson's brandishing is the type of empty threat that the Supreme Court has held is insufficient to support a conviction for carjacking. The government failed to provide additional evidence at trial to show that Mr. Wilson acted with the intent to kill or inflict serious bodily harm when he stole the truck. As a result, this court should vacate Mr. Wilson's conviction for carjacking, as well as the related conviction for brandishing a firearm in connection.
Mr. Byrne?
Yes, sir.
If I understand this case, and I think it'll help us get right to the nub of what I think the issue in this case is the district court seemed to conclude that the elements of carjacking were satisfied not by the firearm, but by when he asked for the keys. And there was a misunderstanding as to where the keys were, that the defendant swelled up, squared up, and was ready to fight. And he stood up and raised his voice and basically suggested, if you don't give them to me, I'll take them by force. I think that Judge Chambers found was the element that satisfied the carjacking element and not the gun. So maybe you could address that, whether he was clearly erroneous in relying on that.
Yes, Your Honor. I would agree that Judge Chambers put a lot of emphasis on those facts.
Well, it's necessary. If he didn't have that, your argument's foolproof, isn't it? I mean,
well,
basically...
I never like any argument to be foolproof. But.
Well, I understand. But it seems to me that Judge Chambers understood that conduct to be the conduct that satisfied Section 2119.
Yes, Your Honor. I think those are the findings that he made. It's clearly erroneous because the actions that Mr. Wilson engaged in still did not demonstrate that he had an intent to cause death or serious bodily harm in order to complete this offense. And in addition to the firearm, when they have this back and forth over the keys, there are some threats that are made. But I would argue that the threats don't really provide anything that the brandishing of the firearm did not. Because certainly that...
Well, the firearm, your argument on the firearm is that he knew it wasn't loaded and it wasn't loaded and that type of thing. And let's set that aside.
Okay.
But let's stick with the facts on which the district court relied. And it seems to me the force doesn't actually have to be asserted. It has to be present if necessary to affect the carjacking. In other words, the attempt or the use of bodily injury or threat of death has to be communicated, I suppose, through the conduct. And I thought the district court concluded that evidence was sufficient, saying basically concluding that asking the witness, was he ready to fight? And the witness said yes. And it seemed to me that was important to the district court.
It was, Your Honor. And the reason I don't think that meets the standard of proving the intent is because the courts have said that when you're considering intent, you have to consider essentially the totality of the circumstances. And the circumstances in this case, as presented at trial, were that Wilson was a single individual and he was dealing with two grown adult men. And the idea that he was presenting proof of an intent to cause death or serious bodily injury by this swelling up and suggesting he might fight them for it does not rise to that level. In other cases where there has been threats of physical violence, it's been.
Do we have to make a judgment about whether he was outmanned or he was heavier or smaller than the person? It seems to me we don't know all those circumstances. I mean, he could have been a karate expert or whatever, but he did seem to present himself in a manner that he was ready to fight and said, I'm going to have to take the keys if you don't give them to me, implying by force. The district court said that revealed an intent, at least of a serious bodily injury if necessary.
I think, Your Honor, first of all, in terms of Mr. Wilson's potential martial skills, that would have been evidence.
Well, I don't know that. I'm just tossing that in. Yeah.
Sure. But in terms of his confronting the two of them and telling them he'll take the keys, I think you have to look at it again in the context of all that had happened up to that point, because we know that shortly before two gentlemen with the pickup truck, he had another incident with the gentleman in front of the auto parts store. And when that gentleman basically pushed back against him and he wouldn't give him the truck and he said, I need to go inside and get the keys, Mr. Wilson didn't do anything to him at that point. He didn't try and cut off his...
Well, he assumed he was going to get the keys because he was told that the man was going to go inside and get the keys, right? And the man instead went inside, locked the door, and called 911.
Yes, but he hadn't really given any indication that he was actually going to give Mr. Wilson the keys.
His behavior increased over time, didn't it, counsel? At one point, he tries to get a vehicle by subterfuge. The next time, he makes a threat, but the man goes inside. The third time, he actually directly threatens to kill somebody. The nature of the threats changed significantly in the exchange. And I don't think the evidence is clear that he knew the firearm was unloaded. There's not evidence in the case that ties those two pieces together. He certainly did threaten to kill somebody. He's got a weapon that can be used as a club, if nothing else. It's not clear to me that he knew it was unloaded from the facts as they came in. And the judge found that he intended to escalate if necessary. Why is that clearly erroneous when we see an escalating pattern?
I think that is clearly erroneous, Your Honor, because we still are left with a lack of evidence that he actually would have engaged in the conduct necessary to complete the offense had there been resistance. As to the firearm...
Well, excuse me though, Mr. Byrne, if he was threatening and saying, do this or you will die, which was the testimony, either help me unload the vehicle or we could die, why isn't that? I mean, in Small, it seems to me that we rejected the argument that you're making here now, that the weapon was unloaded. Why isn't the presence of an unloaded weapon with the escalation of activity, as Judge Myers has pointed out, plus the issuing of death threat, why isn't that enough in this case to demonstrate the required intent?
I think, Your Honor, it's not enough because the threats are empty, and the Supreme Court has said that's not sufficient.
What makes them empty?
Well, because the firearm is unloaded. And that's what the evidence in the case is. It was unloaded when it was given to him. It was unloaded when it was recovered. There's no evidence otherwise. And the government has never argued it.
Okay, but we've rejected that in Small. You can't just rely on an unloaded weapon and be home free. So what else makes your case different from Small?
Well, I think I would have to go back and look at Small. I think there's a difference there between a lack of evidence as to whether the gun was loaded versus affirmative evidence that the gun was unloaded. And I think that is an important distinction. But I also think when you're getting into threats made by the defendant, that it's important not to collapse the two separate elements in carjacking. That is the intimidation element that is common from robbery and the intent element, because the Supreme Court's holding in Holloway is that you can have something that is a threat, and that is a threat that someone believes and acts upon, but is not sufficient to demonstrate the intent of the defendant to actually use deadly force or force that would constitute serious bodily harm.
This was a bench trial, though, and the judge clearly told us he understood that element. He understood it to be a separate element, and that he found that these facts were sufficient to establish to him, beyond a reasonable doubt, that that mental state, in fact, existed. And we have to find that no reasonable jurist could have reached that position. Isn't that correct? I mean, it's not a question of whether or not that element is known to be an element. He clearly understood it to be an element.
Well, Your Honor, Judge Chambers certainly did make those factors. I would argue that I think the judge did tend to conflate the two in his holding, and it's an easy conflation to make because when you have a case like this where all you have are threats, you don't have an action that really demonstrates the heightened intent that is necessary to obtain a carjacking conviction. I'm sorry, I thought there was another question.
No, you can continue.
Thank you, Your Honor. There is, of course, a separate basis that upon which this court could reverse Mr. Wilson's convictions, and that's the Giglio issue, the witness statements that the government failed to disclose prior to trial that were developed during the trial prep process that provided these additional facts that the district court relied on in concluding that Mr. Wilson was guilty of carjacking. In the response to the defendant's post-trial motion, the government admitted that these additional facts were developed in these trial prep sessions, and they were not turned over to the defense prior to trial. The government knew what the testimony was going to be because they laid it out in an opening statement, and they relied on it in closing. And if you go through the Giglio factors, these discussions happened well before trial, although it's important to note that the first trial prep sessions with these three witnesses occurred the day before Mr. Wilson entered his waiver of his right to a jury trial, which goes to, importantly, to that issue. The evidence was favorable to Mr. Wilson. It impeached statements and therefore the testimony that was given by these three witnesses. It was suppressed by the government. The government had the statements, and they knew what the witnesses were going to say prior to trial. And it was also material. The district court erred in concluding that these weren't material facts. And I think Your Honor hit on this by pointing to those additional facts for the conclusion that Mr. Wilson was guilty of carjacking. Essentially what happened was, as we rolled towards trial, the government recognized that with an unloaded firearm, simply brandishing it wasn't enough. There needed to be something more. And in these additional statements, they got the something more. Our position is that even with the additional statements, that is still insufficient to support a conviction. But certainly it's a separate basis for this court to vacate Mr. Wilson's convictions, that the government withheld that evidence that should have been turned over to the defense. And I wanted to point out, in terms of the government's duty to turn over all favorable information, including impeachment information, that's actually part of the standard arraignment and discovery order in the Southern District of West Virginia, one of which was entered in this case. It's actually docket number 18 at page 4. It's not part of the joint appendix, but it is part of the record. If there aren't any other questions at this point, I'll reserve the remainder of my time for rebuttal.
Thank you.
Thank you.
All right, Mr. Adams?
Good afternoon, Your Honors. Thank you, and may it please the court. Your Honors, the most direct evidence of the defendant's intent in this case comes from the defendant's own words. The threats, the verbal threats that he made to the victims, notwithstanding the fact that an unloaded firearm was used during the commission of the offense, those verbal threats, when considered with the entirety of the circumstances surrounding his conduct, all viewed in the light most favorable to the government, constitutes substantial evidence. We've obviously already talked about the verbal threats. There were two separate instances where these verbal threats were made. The first incident occurred when he immediately brandished the firearm upon coming upon our victims, and he makes an express threat to kill the victims. Of course, the firearm in this case, the government, I think, has to concede that the firearm was unloaded. The government wouldn't concede that he knew the firearm was unloaded. I think the record is really silent as to that. But regardless, I don't think that that controls the determination of the case. And Small is a case that is of particular importance here, and Small's already been discussed. Small specifically discussed the use of an unloaded firearm in a carjacking case. In Small, the government produced no evidence whatsoever that the firearm was loaded. The only evidence the government produced in Small as to the firearm is that it was actually a firearm. It was a real firearm. When the defendant in Small tried to make a similar argument that, hey, the government couldn't show this gun was loaded, this court specifically said, first, a loaded firearm is not required under the statute. But second, even if the firearm was unloaded, a reasonable finder of fact, a reasonable juror, could still find that the defendant had the requisite intent, either through using the firearm itself as a bludgeoning weapon, or more importantly, by simply using brute force. So the first threat we have, where he makes a direct express threat to harm these victims, brute force is still enough, and a reasonable finder of fact could find that he had the intent at that point. As the offense continued, we get to the second threat, which I agree the district court seemed to focus more on in his findings. It was at that point when there was some misunderstanding about where these keys were located. He asks for the keys. They told him the keys were in the truck, and either he didn't hear them or he misunderstood. And he makes the second threat at that point, where he says, "Are you going to give me the keys, or do I have to come take them?" That is an unmistakable threat to commit violence to these victims if that's what's necessary for him to retrieve those keys. We're also asking, just like we asked the district court, the court to consider the entirety of the circumstances at the point that that threat was made. This was really at the end of a crime spree that had lasted all day. The defendant at this point had already told the victims that he had been on the run from the state police. He told Mr. Clark, the gentleman that was at the Advance Auto Parts store just prior to encountering these victims, when he confronted him, he told him he was on the run from the police. And he certainly knew when Mr. Clark did not come back out of Advance after about 2 minutes, that Mr. Clark had to have been contacting the police, which would more pinpoint the defendant's location. So that's certainly relevant at that point. And the district court said as much by stating that he was clearly a desperate man at this point. So that's entirely proper for the finder of fact to consider. When you also look at the circumstances of his interactions with these victims, notice he first demanded that the victims take his belongings from the stolen expedition and transfer them to the county vehicle. It was only at the point that he was ready to leave when all the belongings had been transferred when he makes the demand for the keys. At that point, he had no other options other than to get the keys. And again, the district court found accordingly. The district court even commented directly on the use of the firearm. And again, I'm not going to concede that he knew the firearm was unloaded, but even if he did, that still doesn't decide this case for a couple reasons. One, small, that we've just discussed, and two, the district court actually contemplated that scenario. It didn't make a finding that he knew the firearm was unloaded, but the district court did say that even if he knew that he could not shoot the machine gun, that at the point he makes the demand for the keys, that it had no doubt that he would have tried to physically assault the victims if that's what was necessary for him to get the keys at that point. Again, we're asking the court to consider the entirety of the circumstances. When you consider, again, the entirety of the circumstances, it goes back even before Mr. Clark. It starts all the way with this defendant's theft of the expedition. Again, this was a crime spree that he was on that day. The district court expressly found that. He had stolen the expedition. He had knowingly acquired a machine gun. The defendant knew it was a machine gun during the offense. He told Mr. Clark, again, that's the individual at the Advance store, he told Mr. Clark that he had a fully automatic weapon. So he knew that he had a machine gun. He fled from Deputy Young in Kanawha County. And again, that's particularly important because it shows the defendant knew at the juncture when he demanded those keys that he had been on law enforcement's radar, so to speak, that day. It was a particularly dangerous flight from Deputy Young. They both ended up going off-road. He ramped over some railroad tracks. The deputy eventually decided not to follow him, but that shows that he knew that law enforcement was trailing him at that point. After he left where he encountered Deputy Young, that's when he happened upon the Advance store and when he ran into Mr. Clark. I know there's been some discussion from my colleague about the fact that he didn't harm Mr. Clark and how that tends to negate the evidence that he had this specific intent. And I would respectfully disagree, and I believe the district court also considered that possibility. When he encountered Mr. Clark, he approached him aggressively, not as aggressively as he approached the ultimate victims, but he approached him aggressively. He simply tried to talk him into trading cars. But when he saw that wasn't going to work, that's when he turned more aggressive and started making threats. He told him he was an ex-Marine and that he had a fully automatic weapon, that if Mr. Clark knew what was good for him, he would simply get in the expedition, the stolen expedition. And the fact that he didn't harm Mr. Clark wasn't because he thought Mr. Clark was resisting. It was because Mr. Clark simply fooled him. Mr. Clark told him, the keys are in the store, I'll go get the keys for you. The defendant at that point thought that Mr. Clark was actually complying with his demand, and that's what the district court found. So the fact that he did not harm Mr. Clark, it doesn't negate the evidence that he would have had that specific intent. After Mr. Clark entered the store, the testimony was it was approximately a 2-minute period that the defendant remained in the parking lot waiting, presumably for Mr. Clark to return with the keys. It was at that point that it's apparent that the defendant sort of figured out that Mr. Clark wasn't coming back out. He circled around the store, and that's where he went to a separate location in the shopping plaza where he encountered these victims. So all that leads up to, again, the very last threat that he made these victims which was the threat to take these keys by force. He knew that law enforcement had pinpointed his location. He knew at that point that all of his belongings had been transferred over into the county truck. At that point, if the victims had resisted his demand for the keys, that's when the district court clearly said that even if he couldn't shoot the machine gun, he would have physically assaulted them at that point to get the keys. And again, we know from Small that brute force is sufficient for a defendant to commit a carjacking. So when you consider that evidence in a light, again, most favorable to the government, that does constitute substantial evidence. Just as to the threats, when you consider the threats in a light most favorable to the government, that means the defendant meant what he said. If he makes a threat, there are really only two possibilities, Your Honors. One is that it is a bluff, which we know is certainly not enough under Holloway and all the other cases. The only other possibility is that it's not a bluff and that he meant what he said. And for this court on the standard of review, considering that threat in a light most favorable to the government, that means that he meant what he said when he said that he would come take the keys by force from the victims if that was necessary, what the court ultimately found. Just speaking briefly as to the district court's decision to deny the motion for a new trial, the district court did not abuse its discretion there. The district court found that first, that the testimony regarding the defendant's demeanor during the interaction with these victims was not inconsistent with the victims' prior statements. The victims gave a written statement the day that this incident occurred. They both gave a written statement. Both victims testified before the grand jury. Both of the victims in the written statement and in their grand jury testimony described the threat that the defendant made to take the keys by force. That was not some new piece of evidence that the government sprung at the last second. The defendant was well aware that this case went far beyond the fact that the defendant would have used an unloaded machine gun. So the district court correctly found that that testimony was not inconsistent. As to the other instances of cited testimony, the district court found that it simply wasn't material, and it's not material for two reasons. First, the defendant was able to cross-examine each and every witness at trial with the information that he is now saying the government withheld in violation of its duties. So the defendant was able to effectively use the material at trial. Beyond that, the second reason it's not material is because the district court himself leaves no doubt as to how the court considered that evidence. The district court said that although the information regarding the defendant's demeanor at the moment that he made the threat to take the keys by force, although that was not inconsistent with the victim's prior statements, even if the court had not have heard the testimony regarding the demeanor, he still would have found that the government had established the specific intent element. And the district court really used some strong language in regards to that. The district court said in his opinion and order denying the motion that it was inconceivable to the district court that the defendant would not have had that intent at the moment that he threatened to take the keys by force. As to the other cited evidence regarding the state trooper, the district court said he simply did not consider that as part of his findings regarding the defendant's specific intent in this case. That was also consistent with how the district court viewed that at the trial when he was making his factual findings and rendering the verdict. The district court agreed with the defendant. He said that the testimony regarding the chase, which we haven't talked about much here today, but the chase after he left with the county truck, that testimony was of limited import. That's what he said in making those findings at the time that he rendered the verdict. He said he agreed with the defendant. He said that chase could, of course, speak to the defendant's state of mind, but the intent, of course, has to be established at the time that the defendant demands or takes control of the vehicle. So the court really considered that of limited import. And again, as to materiality, he says it simply had no effect on the court's verdict in this case. Excuse me. So just to sum up the issue regarding the motion for a new trial, this is obviously not a case where a defendant has discovered some information or some evidence months after, and we have to speculate or try to analyze how that would have affected the case if it were part of it. In this case, the defendant was able to use the information which he now cites to. Secondly, we don't have to speculate as to how that material affected the verdict in this case, because the district court tells us directly that even without that information, it was inconceivable to him that the defendant didn't have the intent. The last point I want to make, Your Honors, is that the defendant in this case is consistently, and again, with all due respect to my colleague, has consistently tried to frame this case as one where it was just a simple legal issue as to whether the use of an unloaded firearm was sufficient to establish the specific intent. And the evidence just simply went far beyond that. Again, you have all the evidence of the crime spree. You have the evidence of the interaction with Mr. Clark, the gentleman in advance. And you have, most importantly, the defendant's direct threats on two separate instances with these victims, which is in addition to his brandishing of the weapon. So the evidence that the defendant knew from the very instant that the government turned over the first statements of these victims went far beyond the fact that he simply would have used an unloaded firearm.
Counsel, the fact that the Giglio material was adduced by the government at trial, doesn't that significantly undercut the argument that this is exculpatory information and would undercut the government's case, since it was introduced by the government during its case entry at trial at a time when the defendant had full opportunity to respond to it?
Yes, Your Honor, I would agree. This is not exculpatory information. The government certainly never viewed it as exculpatory information, and the government really never viewed, again, the information regarding the defendant's demeanor as anything other than consistent with what the victims had already said on two separate occasions. It certainly wasn't.
And the court so found?
And the court so found that that information was entirely consistent, again, with the victims' prior written statements as well as the victim's grand jury testimony. Yes, Your Honor. I'm happy.
All right, is that it? Does that cover it?
Yes, Your Honor. Thank you very much.
Thank you. Mr. Byrne? I think you're muted.
Yes, I was. Thank you, Your Honor. I want to talk a little bit about, we've talked about threats, and particularly in the context of the Giglio discussion. Threats are not enough. The issue is whether there is an intent to follow through on the threats. And what the latter developed information that the government presented for the first time at trial is that Mr. Wilson was going to square up and puffed up and was going to fight these guys. Matter of fact, the word fight was brought up by the government. It wasn't testimony. And so what that information did was it changed those threats from potential empty threats to ones that he might have tried to act upon. And so I think that makes it that evidence a little bit more, well, it certainly makes it exculpatory in the sense that it goes to the impeachment of those witnesses.
I was going to say it's hardly exculpatory. You would have to make the strategic decision to use it. If they disclosed it before trial to you, the best you get from it is impeachment. The potential difference between what was in the statements and grand jury testimony on the one hand and the demeanor that was revealed later. And the benefit to you would have been to use it for impeachment, but you did use it for impeachment, didn't you?
Well, I think counsel made the best use they could of it on short notice. They had no idea what it was until opening statements. But I think that's also where it's important to consider how this impacted Mr. Wilson's decision to waive his trial in front of a jury and proceed to a bench trial. Because if he had been aware that this was going to be a factually disputed case, he may very well have decided that it was something he wanted 12 jurors to decide instead of a single judge. But also talking in terms of...
We don't have any evidence of that, do we? I mean, when the man testified, you didn't stand up, or his counsel didn't stand up and say, hey, I'm surprised by this. In view of this, I wanted a jury trial.
No, Your Honor. Yeah. Only in our motion for a new trial where we raised that. Yeah. As to the issue of materiality with the Giglio, I think it's important to note that materiality is not a sufficiency analysis, and thus it's not sufficient for the district court to say, well, even without this evidence, I still would have found him guilty. The question is whether this evidence casts doubt on the verdict, on the confidence of the verdict. And I think it still does that, even if the district court, incorrectly, in my opinion, would still have convicted Mr. Wilson without that. Going back to the sufficiency argument very briefly, on Small, I think this case is distinguishable from Small for two important reasons. One is the one I mentioned earlier, but I confirmed while my colleague was speaking. In Small, there was no evidence about whether the gun was loaded. In this case, the only evidence is that the gun was not loaded. And therefore, that's a difference. But the other difference in Small is that Small was part of a group of 3 defendants who accosted a single person. They had a numerical advantage such that a threat to do some sort of brute force violence to the victim actually carried some weight. It's entirely different than a 20-year-old kid allegedly squaring off with 2 full-grown adults. One other thing I wanted to...
Counsel, the court had the opportunity to look at the defendant and at the 2 witnesses and make his own determination that we don't have the opportunity to do about whether or not that threat was genuine given the age and relative size and strength of the individuals, right? The court said specifically, I believe the evidence establishes he had the intent to do bodily harm if either Thaxton or Francisco had refused to let him have the keys to go away. So this is not a question about whether or not the judge understood the element or the judge was able to observe the individuals and make that judgment for himself, right?
He certainly had the ability to observe the witnesses and the defendant, but I believe any conclusion that the judge drew from that, there's no record evidence to support a determination that Mr. Wilson really would have taken on these two full-grown men. The last thing
I don't know, that suggests that he wouldn't take them on unless he determined he would win. But what the district court found was he was desperate. All his gear had already been loaded onto the truck, and he needed to get away. He was being pursued by the police. He knew that. And he basically said, I'll have to take it away from you by force. That really appears like a genuine intent to use assault. And the court said, if he hadn't gotten his way, I believe and find that he would have at least tried to physically assault one or both of these individuals to get the keys to do whatever was needed to do to be able to get away. And that is a finding of the necessary intent under 2119, isn't it?
It's a finding, but I think it's an incorrect finding, Your Honor.
Okay.
And I'd point out, if I could, I know I'm over my time, I just want to make one final point. At the time there was the back and forth about the keys, you mentioned that his gear was already in the truck. That's because Thaxton in Francisco had decided they were going to let him have it.
Well, no, they didn't decide. He threatened to kill him. And he had this gun,
Well,
he was brandishing it, and they didn't know whether it was loaded. Now, that threat may have been empty, but they didn't know that. So they had made a decision. They're not going to engage this guy. They're going to help him. But then when it comes time to get the keys, the court acknowledged the gun was on the seat, but that the defendant still threatened to use force to take it from him. Now, whether he used the force and would have won is not the issue. It's whether the victims would have been hurt, seriously hurt. And I think the implication is that they would have been. The court found that they would have been because you had a desperate man. That's a finding. I mean, and the question is, the standard isn't whether it's the only finding, but it's a finding the court made, and we just determine whether it was clearly erroneous or whether there was substantial evidence to support it.
Agreed, Your Honor. And I think the thing I would leave you with is that if it's the discussion about the keys is what turns us from an empty threat to intent sufficient carjacking, the government to prove more before it sends a 20-year-old to prison for 30 years.
All right. Thank you.
Thank you.
Mr. Byrne. At this point, we would come down and greet counsel. Both of you probably know that. That's our practice, and we would not have denied you that. This is the first time I recall we've ever not been able to do it, but we'll do it virtually and greet you and thank you for your arguments. When you come to court again, remind us and we'll give you a double handshake. Thanks for coming, and we'll take a short recess and reconstitute the case for the next case. Thank you.
Thank you, Your Honor.
This honorable court will take a brief recess. Court of Appeals for the Fourth Circuit.
Thank you. We have Ms. Platt. Can you hear me?
Yes, sir.
And Mr. Young, you hear me?
I can, Your Honor. Thank you.
Okay, we'll take up the final case for hearing today, U.S. versus Pulley. And Ms. Platt, why don't you begin?
Thank you, Your Honor. Good afternoon, and may it please the court. I'm Caroline Platt here on behalf of Craig Pulley. The district court erred when it denied the motion to suppress under Franks v. Delaware because the police detective in this case made false statements and omitted materially important information about informant credibility in reckless disregard of whether the magistrate would be misled. This case is indistinguishable from this court's opinion in United States versus Lull from 2016. The rule of Lull and other cases is that when a police officer uses information in a warrant affidavit from a source that the police officer knows has lied to the police, and particularly about the crime being investigated and about which that's the subject of the warrant, it is reckless omission under Franks and Lull as a matter of law not to advise the magistrate of that informant's credibility problems. This is a quote from Lull at page 118. When the information forming the basis for probable cause comes from an informant, the informant's veracity and reliability are critical to the totality of the circumstances test. That's Lull quoting this court's decision in Wilhelm, which itself is quoting Illinois versus Gates. Because this case is indistinguishable from Lull, the district court's denial of Mr. Pulley's motion to suppress was error, and we would ask this court to reverse. So as to the intentionality prong of the Franks test, we submit that Detective Howard's affidavit was recklessly misleading to the magistrate because she omitted several pieces of information that directly bared on witness Daryl Blunt's credibility.
Counsel, can I ask you, when you say recklessly, does recklessly require that the affiant, or the officer in this case, the affiant, advert to the risk? Is it a personal knowledge requirement? That is, must she recognize to herself, by omitting this, I'm likely to it's possible I will mislead the magistrate?
No, Your Honor, I do not think that there's a personal...
So it's gross negligence, not recklessness?
I'm not sure I understand your question. It's not a gross negligence standard. It's a recklessness standard. But right. I'm not sure I understand Your Honor's question. She does not, it's not an intentional standard. It's the circumstances of this case.
Intentionally mislead means I know this will be misleading and I'm going to do it. I
Correct.
Want to mislead the person.
That is
Reckless
not...
means I'm aware this may mislead the magistrate, but I'm going to run the risk that it might.
I'm not sure that I agree that that's what recklessness means. I agree with your, I don't know that I agree that that's what recklessness means. I agree with your definition of intentionality, and that's not the intentional intentionality. It's complicated, as I think Your Honor is getting to, because the prong of Franks is called intentionality, but it encompasses both intention and recklessness as a matter of law. So
we ordinarily say recklessness requires that the person advert to and choose to run the risk, right? If that's an element. The question is, in this circumstance, is it different? Is it a different kind of recklessness? Does it require gross negligence is sufficient to meet recklessness, or is it something else?
So, Your Honor, if you're referring to tort law, that's not what the Franks cases that I've read from the Fourth Circuit discuss. And so what I would say is that the type of recklessness, for example, that the police officer in Lull was found to have encompassed is exactly the kind of recklessness that Detective Howard in this case encompassed, which is to say... Yeah, but
it seems like in this case, the circumstances seem to be significantly different. The district judge spent a lot of time on this. He was very careful. He heard a lot from the detective, Detective Howard, and it turns out that Detective Howard put in the statement that Blunt provided information found to be credible. And that isn't a true statement, because he revealed the location of the clothes and he revealed the location of the gun, both of which proved to be accurate.
So, Your Honor...
just a minute, let me finish. Her intent was to indicate that testimony, which she revealed about the clothes and the gun, was accurate. Now, she did not put in the fact that Blunt had told a different story when he first started talking to her, which would go to his overall credibility. But she did reveal that the evidence he provided on which she was relying was accurate, and that in fact was true. And the district court went through this at quite some length, the whole methodology, the whole efforts of Detective Howard to put this case together as a complex set of cross facts.
Here's the problem, Your Honor, is that...
Hey, just a minute, can I finish, please? And she revealed all this to the district judge, and the judge found that there was no intent to mislead. That was a finding he made. Now,
well, and we're not alleging, we're not alleging intent. Again, we're alleging recklessness. And her recklessness, again, is identical to the recklessness of Investigator Welch in Lull. If you look at pages 116 to 118 of the Lull decision, this case is directly on all fours and controlled by Lull.
Except the credibility of the informant was at issue there. The whole credibility.
Correct.
The credibility is not on issue here.
Daryl
made a statement. She made a statement that the information provided was credible. In other words, she could have just said the information was accurate. That's what she was saying.
Daryl Blunt, but
Hey,
here's what she...
Ms. Platt, can I interrupt for just 1 second? I think perhaps it would help your argument if you would tell us what she intentionally or what she recklessly withheld. It seems to me that she knew that Blunt had committed the robberies. She knew he was in the pharmacy during the third robbery, okay? She knew that he had lied about the purple gun in the holding cell when the gun was identified by another detainee. Tell us what else factually you're relying on.
Yeah,
she knew that, okay, just one other thing. She knew that the defendant was incarcerated during robberies 1 and 2. She didn't give any, and Blunt said that he had, that the defendant had participated in all these robberies. So she knew that Blunt was lying about at least these 3 things. Were there other things in the record that she knew Blunt was lying about that you could bring to our attention?
Right. So thank you, Judge Keenan. That's several of the things I was about to say. And this is why the recklessness intent of Detective Howard is exactly like, or perhaps worse than that of Investigator Welch and Lull, is because in these facts and other facts that I will bring up, Judge Keenan, she usurped the role of the magistrate. So she's co-opting the structure of the criminal justice system by, and it's the 4 quotes from Lull on pages, again, 116 to 118. She is determining which parts of Blunt's statements are credible and non-credible, which is under Lull and Franks and Gates, the role of the magistrate to determine which parts of the statements are credible and non-credible. And so this is again a quote from Lull, deeming the informant reliable for some purposes, but unreliable for others is an assessment that is for the magistrate, not Investigator Welch, to make. That's a quote from Lull at page 116. And so, Judge Keenan, as you say, particularly the hiding of the purple gun in the holding cell that Daryl Blunt did, and then he lied to the police officers and denied that he did that, even though they had him doing it on video, is worse than the informant in Lull pocketing the $20 of buy money, because the gun was used in the robbery. And so it is inherent in the robbery transaction, even more so than the $20 of buy money in Lull. And that's why this case is controlled by Lull. Much as stealing the buy money made the informant in Lull unreliable and something that the magistrate should have been able to consider in considering the informant's reliability, Daryl Blunt lied to the police about hiding the gun used in the robbery in the holding cell at the jail during his interrogation by the police, and lied to the police about that. And so Detective Howard usurped the role of the magistrate judge by not allowing the magistrate to consider that as part of his credibility determination. So it was the lying to the police about the gun. He lied to the police about who hid the clothing at the motorcycle club, which the police knew. He also, I'm sorry, there were other lies and omissions.
Counsel, is it clear that she lied about that? The record doesn't suggest she lied. The record suggests she was hearing information. She fixed her file later and the later file is inconsistent, but it doesn't suggest she knew that that was the case at the time or that she lied about it.
Well, it's clear that she withheld the information. So to lie is a strong word. You're right, Your Honor.
Well, and it's not clear she withheld it either, that she had to have known it at the time. And that's not clear that that was the evidence that came to her from the detective who was monitoring the phone call.
The detective who monitors the phone call, and Your Honor, I have the citation, and I can definitely get it for you by the time of my rebuttal. He testified at the very end of day one of the suppression hearing, and he said for sure that the item about the clothing, that he definitely wrote it down, he definitely put it in the tray, and he definitely said it outside and out loud. And she testified at the hearing, and again, I'll be happy to get the citation for you certainly by the time of my rebuttal. And she said that she definitely more likely than not knew about the gun as well. That's finding a gun in the holding cell is certainly a major incident at the thing. She said she more likely than not knew about the gun as it happened.
I'm talking about the clothing part.
Yeah, so I can find the test. I think his name's not Blau, but his name starts with a B. That he testified at the very end of the first day of the suppression hearing that he made that known to the entire team. And the other thing is that, as the district court noted, under United States versus Blauvelt, the collective knowledge doctrine applies as long as it's the investigative team. It's not every law enforcement officer in Norfolk, but as long as the investigative team knows, under United States versus Blauvelt, that is sufficient for a misleading warrant affidavit. And these officers are all part of the investigative team in this case.
Ms. Platt, I've got a follow-up question. Judge Davis, as Judge Niemeyer observed, does a very thorough job. But I think he left one gap here, and that is he made a finding on intentionality, but he only addressed reckless disregard with regard to the single issue of whether the defendant was in jail during the first two robberies. He said that the police officer, Officer Howard, did not act with reckless disregard in omitting that fact. But I don't see anywhere in the record that Judge Davis ruled with regard to reckless disregard as to the other items. Is that evident? Is there anything in the judge's ruling that addresses reckless disregard other than the information regarding the defendant's incarceration during the first two robberies?
I agree with that analysis, Judge Keenan, and I think that's how I presented in my blue brief.
Where does that leave us? Yeah,
So,
where does that leave us then? It looks like the judge didn't do part of the job. Do we send it back to him?
I think not. And so I've been thinking about this question because I'm sort of a structured analysis type person as well. And I think the court in Lull itself found reckless disregard, I think particularly because it's not a finding of intent to get back to the sort of tort law. The court in Lull itself, this court in Lull, decided that the officer had acted with reckless disregard as a matter of law. And I think this court can do that as well, because it's sort of a mixed question of law and fact.
Yeah, how do we do that? You know, it's one thing in Lull where somebody's stealing, I mean, you know, and, you know, the $20, right?
So Judge Keenan, in this case, I think where Darrell Blunt hid the gun used in the robbery in the jail cell, I think the fact that Detective Howard neglected to tell the magistrate about that, as well as that fact that he lied about who hid the clothing.
I agree with you. It's a real problem. But I'm just wondering whether we don't want to give the district court the opportunity to pass on that.
I certainly think it's an option, Your Honor. And to be frank, and to be clear, this shouldn't matter to the legal analysis. My client has already finished serving his jail sentence, and so it wouldn't actually make a difference in that regard if you do want to remand, because he's already out. But I think, if anything, the reckless disregard in this case, because of the 4 omissions and because of the hiding of the gun used in the robbery, to me, that's more egregious than the $20 in buy money. And because there are 4 of them, so I think if the court wanted to, it could find reckless disregard as a matter of law, just as Judge Duncan did in Lull. The other thing I would point out sorry, Your Honor.
There was a finding. He said that he found her entirely credible. And that's why I was asking about whether or not what recklessness means in this Franks context. If he finds her entirely credible, then he is finding that it did not occur to her that it was going to be misleading. He said, I found her to be entirely credible, that she had no intent to mislead. And that would, if recklessness encompasses adverting to and choosing to run the risk of misleading, then I think it does answer Judge Keenan's question, which is, I think it's essential we actually know what reckless means in this context.
So, Your Honor, I think that's why I don't want to say that it's gross negligence, because I don't think that's what recklessness means. But it's clearly not intentional intent, to use a terrible phrase.
I understand reckless means advert to and choose to run the risk in most circumstances, and the question is, in some tort circumstances, we let gross negligence, truly gross negligence, stand in as recklessness because we can't believe it would not have crossed the person's mind. And so my question is this a finding that it did or did not? Did it have to enter, the risk have to enter her mind or not?
So I think, Your Honor, if I may offer, again, to get back to Lull, because it's so rare for me to have a case that I think is on all fours, like so closely on fours with such a fact-based case. There's several quotes. I'm not going to read you all of them, especially because I see my opening time is about to expire. There's a bunch of language, again, on pages. It's all between 116 and 118 of Lull that say things like should have been obvious to Investigator Welch, and every reasonable person would know. The magistrate would want to know this. There's a lot of language that, whether Your Honor wants to decide that it's a gross negligence standard or adverted to the risk, or what that's for Your Honors to decide. But all of these should have known, should have been obvious, must have known, whatever they are, I think they get to reckless disregard for misleading the magistrate, which is the standard from Franks and Lull that I would say that I, on behalf of Mr. Pulley, am not asking for a new rule. I'm really just asking this court to enforce the rule that has already been imposed.
Well, what about the district court's additional ruling that it wasn't material?
So,
that's
Your Honor,
another element of a Frank's.
Yes, it is, Your Honor. And this is, I was about to say to Judge Keenan, if I may answer you very quickly, even though my time has expired. The district court did not address the remedy under Lull, which is on page 118 of the Lull decision, that when the magistrate has been misled about informant credibility, the remedy under Lull, which is on page 118, it's not to add the information about the informant credibility problem. The remedy under Lull is to excise every piece of information from the warrant that came from the informant, which in this case is Darrell Blunt. And so, except
some of that information, that's the big distinction between Lull and this. Lull was focusing on the credibility of an informant. This case was not. This case was focusing on the credibility of some evidence provided by the defendant. That evidence proved to be true. And so the real question then is, you can't exclude that as a prophylactic rule, because there was no decision that he's a credible man.
Well, so,
but Judge Niemeyer, she was tracing. Can you let me finish, please? There was tracing evidence in this case from various different sources, and the court was fully persuaded by the carefulness of the detective and her credibility. And it seems to me that if you put in everything in this case and not delete the whole evidence that Blunt provided, because some of it was actually true, then you have the materiality finding that the district court made, and I don't know how you get around that either.
So that's the drug buy in Lull actually happened, and so that is the argument that was made in Lull that the Lull court actually rejected. The pocketing of the buy money happened after the drug deal was complete, and so that does not distinguish this case from Lull in any respect, because the government in Lull actually made that argument that there was no reason to because the pocketing of the buy money was after the person managed to buy the drugs from the defendant, that there was no reason that the two things were separate, and the court rejected that argument. So the Lull remedy is in fact to excise all of the information that comes from the informant whose credibility the magistrate has not had the chance to judge, because it's about protecting the structure, like the separation of powers role of the magistrate being the person who gets to judge informant credibility, because it's the magistrate's role as a neutral arbiter that's being protected in this circumstance.
Okay. Thank you.
Thank you, Your Honor.
Mr. Young?
Good afternoon, Your Honors. May it please the court. The government and the defendant disagree about two fundamental questions that color the entire case. The first is, what kinds of warrants are these? And the second is the rule in Lull as broad as the defendant suggests? And I want to start with the first question. What kinds of warrants are these? And Judge Niemeyer, this gets exactly to the point you made. Under the totality of the circumstances test in Illinois against Gates, if someone comes to police with an incriminating piece of information, the police can do one of two things. One thing they can do is try to buttress the veracity of the accuser. And in that kind of case, the engine in the warrant that is creating probable cause is the truthfulness of the speaker. And that's what happens in most drug cases involving confidential informants. But the other thing the police can do is they can go out and they can try to corroborate the accusation wholly independent of the credibility of the person making it. And the defendant keeps trying to make this the first kind of case, and it is the second kind of case. It is crystal clear it is the second kind of case. Detective Howard was on the stand for 4 hours. She testified extensively before Chief Judge Davis that she thought that what was doing all of the work to create probable cause here was the phone records and the clothing. And I want to pause on the phone records because the corroborative weight of the phone records here is enormous because it corroborates Mr. Pulley's involvement in at least 4 ways, right? Way number 1, Darrell Blunt receives a phone call from Craig Pulley at the exact moment he is caught on camera during robbery 3. Number 2, the victim in that robbery hears Darrell Blunt say, "We're good in here, we're good in here," which supports the inference that Blunt was talking to an accomplice, not somebody who had just happened to call him when he was committing a robbery. 3, Darrell Blunt called Craig Pulley before the 4th robbery. And 4, Darrell Blunt called Craig Pulley after the 4th robbery. All of that was in the residential search warrant affidavit, and all of it is extraordinarily corroborative. And that flows immediately into the second question. Is the rule in Lowell as broad as defense counsel suggests? And the answer is firmly no. In the government's view, there are 3 salient features of Lowell. First, the police in that case clearly thought that the controlled by alone created probable cause to search the residence, which is why they did not make any statement about the informant's credibility in the affidavit. This court concluded that was wrong as a matter of law. There's no per se right to search a house after a controlled by. So second, that means the entire affidavit in Lowell turned on the veracity of the accuser. It converted the affidavit from one that relies on corroboration into one that relies on the truthfulness of the speaker. And
hey, Mr. Young, if I could ask you, what information do we have here? We have the phone calls. We have the phone call during the 3rd robbery and the phone call before and after the 4th robbery, okay? What else do we have here that's independently verified?
We also have the statement during robbery number 3 that what Darrell Blunt said to the person on the phone is, "We're good in here, we're good in here," indicating that he was speaking with his accomplice. One of the things that the defendant says in his briefing is they had the same paper route and they talked all the time. But that's an independent statement from the victim.
Okay, I need to ask you to, Mr. Young, I need to ask you to slow down a little bit. I don't know if it's the transmission feed, but I'm having a little bit of trouble keeping up with you.
I appreciate that, Your Honor, and I will do so. The statement that what Mr. Blunt said during the robbery is, "We're good in here," indicating that he was speaking to an accomplice or a co-conspirator, came from the victim of that robbery. So that's also independent. And the last thing is the clothing. And I want to touch on the clothing for exactly the reason Judge Myers mentioned. The key transcript page is 487. Detective Howard testified she did not find out about what Darrell Blunt had said in his jail calls until after Mr. Blunt and Mr. Pulley were both in custody, which means after she had sworn out the residential search warrant. And contrary to my friend, I think this court made quite clear in Massenburg that the collective knowledge doctrine does not apply in the search warrant context like this. What Blauvelt says is that it applies in the other direction. So if a captain says to a sergeant, "Go arrest that man," it's not an argument in favor of the illegality of the arrest that the captain didn't tell the sergeant everything he knew. But Massenburg says we don't do the inverse when it comes to the affiant for a warrant. And the last thing I would say, and I didn't pick up on this until my second time through the record, but I think it clarifies things in a way that's very helpful. Detective Howard is the person who executed the search warrant on Darrell Blunt's car before Craig Pulley was arrested. The robbers in the 4th robbery wore 2 different outfits. One was dressed all in black in a ski mask, and one was dressed in a safety vest with a baseball cap and a construction helmet. police found the ski mask when Detective Howard searched Daryl Blunt's car. This is at JA 86. It's in her notes. So part of the reason she says repeatedly as she's testifying, I didn't think who discarded the clothing mattered, is because what she had in hand was an outfit recovered from Mr. Blunt's car that seemed to match one of the robbers in robbery number 4, and an outfit recovered from Mr. Blunt's motorcycle club that seemed to match the other robber from robbery number 4. So she quite reasonably assumed that either Craig Pulley threw it away himself or Craig Pulley gave it to Mr. Blunt to throw away. But it never even crossed her mind that they were Mr. Blunt's own clothes. And she says under oath, in the era of DNA, it's inconceivable to me that he would have produced his own clothing in an attempt to point the finger at Mr. Pulley. So on our view, the clothing also is strongly independently corroborative here. And so Judge Keenan, I want to address your concern about the firearm with an example where I think we might lose. There are some cases where the warrant affidavit rests on the notion that somebody has made a statement against penal interest when they confess to a crime. So imagine this affidavit with no independent corroboration. So now it looks like lull. And Daryl Blunt had come in and said, you know what, I'm going to give it up. I confess, I did these robberies, but so did my friend Craig Pulley. And Detective Howard had left out the false statement about the gun. I might lose in that case. But the reason that I would lose is because that's an affidavit that turns on the credibility of the speaker. What the police officer is saying in that kind of case is, Daryl Blunt has given it up. He's cut the nonsense. He's now cooperating. You should believe him. And if in the exact same interview he lies, obviously a reasonable person would understand that that would go towards undermining probable cause. But Judge Myers, this gets to your point about what does recklessness mean. What the court said in Miller against Prince George County is that recklessness in this context is knowledge that leaving the statement out will render the affidavit bereft of probable cause. And I agree with you. When Chief Judge Davis made his credibility finding at page 652 of the appendix, and he said, I've listened to Detective Howard testify for 4 hours, and she absolutely did not intend to mislead anybody, that is sufficient to conclude she wasn't reckless. And that's in part, and I think this
so
is
you
another...
think that he ruled, so you're saying that Judge Davis ruled on more than just intentional disregard with regard to the defendant being in jail during robberies 1 and 2, because I couldn't find, it seemed to me that Judge Davis was very methodical and really did a very judicial, lawyerly job of just marching through everything on intentionality and then starting with and specifically addressing reckless disregard, leaving out the information on that the defendant had been incarcerated on robberies 1 and 2, but then kind of dropped the ball on robberies 1 and the rest of the information with regard to the reckless disregard analysis. And you're saying that didn't really happen because he said he believed the officer? In other words, it doesn't matter that the trial judge didn't specifically address reckless disregard with regard to the other items because he did say he found her credible. Is that pretty much your argument?
Well, let me be very clear. Judge Keenan, your eagle-eyed reading of the transcript is 100% correct. That's exactly what Chief Judge Davis did. And I have a couple of responses. The first is because he doesn't find materiality, I don't think there needs to be a remand. I think you can affirm on that basis independently. But the point that I was making in response to Judge Myers's questions is that in this kind of case, the materiality inquiry and the recklessness inquiry feed into each other in the following way. The reason Detective Howard was not being reckless is because she was absolutely convinced she was writing an affidavit based on independent corroboration, not the veracity of Daryl Blunt. And unlike in Lowell, that's not legal error. She was right about that. The strength of the corroboration evidence here is very strong. And so another way to perhaps say it, Judge Keenan, in one sentence, is given the way the circuit has defined recklessness, at most on this record, I think the court could say, if it decided that this corroboration evidence wasn't strong, which I disagree with, but I think the most it could say is a good faith mistake about the strength of corroboration is not recklessness.
Actually, I think we've said in several cases that recklessness requires actual knowledge of the risk of misleading and disregarding it. And it seems to me that when you are totally innocent of any effort to mislead, you're not knowledgeable of a risk that you will be misleading and not paying attention to the risk.
I agree completely, and I think that's an application of the definition in Miller
Mr. Young, let me ask you a question about materiality. First time I read through the briefs, this kind of flew off the page for me when I turned to Judge Davis's opinion. He seemed to be analyzing materiality in an incremental fashion rather than the materiality collectively. Does that make a difference here?
I don't think it does, Your Honor. And I don't think it does because I don't think this is a case where the Lowell remedy is appropriate. In other words, Judge Niemeyer said this a moment ago. I think on these kinds of facts, you just add all the information back in. And I want to explain why. I think my colleague, Ms. Platt, reads Lowell as though it says, anytime, anywhere, any information bearing on credibility is left out of an affidavit, strike everything. That is not our reading of Lowell. That's so for a few reasons. First, to even be in the Lowell sphere, there has to be no evidence of corroboration. It's not even a Lowell case unless there's no evidence of corroboration. And here the evidence of corroboration is extensive. The second point that I would make about Lowell is that if the rule in Lowell were as my colleague argues, Lowell would be a much shorter opinion. But instead what happens is that the panel in law drops a footnote to this court's opinion in Coakley, where the court says in no uncertain terms that there is no Brady or Giglio obligation to disclose all exculpatory information at the warrant stage. And then what Lowell does is it says, here are all these very specific case-specific reasons, and it lists 4 of them, why effectively already these officers acted in bad faith. That was the problem in Lowell.
Okay, let me ask you another question. It looks like from looking at the record that the purple gun from the jail cell was turned over to Detective Howard on October 17th, okay? And the affidavits were signed on the 20th and the 23rd of October. So I thought you told me that she didn't know about the purple gun. It looks like she had it. Pardon?
The clothing. She didn't know about the jail call about the clothing.
I'm sorry, this feed is not good.
Let me try to switch microphones, Your Honor. Maybe that will help.
Okay. It looks like she had possession of the purple gun. It was turned over to her on October 17th, 2017. And she signed the affidavits on the 20th and the 23rd. So it looks like she knew about the purple gun episode.
Can you hear me now, Your Honor?
Yes.
Mm-hmm.
Excellent. The clothing. I was referring to the clothing. She didn't know about the jail call involving the clothing.
But it looks like she did know about the purple gun.
That's exactly right. That's exactly right.
And that's just that wasn't material to his credibility. I mean, he had denied participation in the robbery, and he in fact had in his possession the gun from the 4th robbery, and that's not material to his credibility.
Judge Keenan, this goes back to the opening and me picking up on Judge Niemeyer's line of questioning. If this were the kind of affidavit that depended on his credibility, absent corroboration, I think I might lose because of the.
I guess our disagreement is how much corroboration is in there in this case. It seems like really the only corroboration you've got are those phone calls, right?
But
I think if I can just clarify the issue, I think the issue is whether when the evidence is corroborated, she's actually relying on the evidence itself rather than the statement made by Blunt. Blunt says where the clothes are and says where the gun is. That turns out to be true information, and she finds that out. She does not rely on the fact that independently he's credible about things that are not corroborated. And she doesn't rely anywhere on his credibility. She just relies on the information he provided that had been corroborated.
And I'd say two things about that in response to Judge Keenan, your question, because I completely understand the court's concern. The first thing that I would say is, in some ways, I think the most illuminating pages of the joint appendix are 618 through 620, because that's where Corporal Paul Fedorko, who is Detective Howard's supervisor, who reviewed the warrants, testifies. And he gets into a back and forth with Chief Judge Davis, in which he says, look, Your Honor, I've been a detective in Norfolk for 12 years. We do not do search warrants like we were in a drug unit. We do not train our people that they are trying to bolster the truthfulness of the people providing information. We train our people to independently corroborate the evidence that they get. And that's the reason that Detective Howard is approaching the case in the way she's approaching it. And then Corporal Fedorko says, look, Your Honor, I've been to trainings with the Commonwealth's Attorney's Office. I've been to trainings with captains and lieutenants. This distinction between warrants that rely on veracity and warrants that rely on corroboration is core to the way we approach our business. And I think that means one of two things is happening here, right? Either the entire Southeastern Virginia approach is wrong as a matter of law,
Sure, or you're saying that, yeah, so you're saying, and I don't mean to cut you off, but I just want to make sure we get this in. So you're saying this warrant did not depend on his veracity at all?
That's exactly what I'm saying. I think, Your Honor, if...
How could it not? I mean, it's the guts of the information.
I disagree. And the example that I would give, Your Honor, and the court may agree with me on this, it may not. Imagine the same facts, so they know Blunt's involved in one of the robberies, but Blunt asks for a lawyer immediately, and he never talks to police. If the next week, police got an anonymous tip in a letter that said, I know you have Darrell Blunt in custody. You should know he did the robberies with Craig Pulley. And then Detective Howard goes and looks at the phone records, and she sees that Craig Pulley calls Darrell Blunt during a robbery where he's obviously speaking to an accomplice. And then Blunt calls him before and after the fourth robbery. I would think that's enough. And here we have the clothing on top of that. And for the reasons we've discussed, I don't think the clothing is problematic. So I think, Your Honor, I just disagree about the strength of the corroboration here. I think when you...
If I understand you, Mr. Young, I think what you're saying is that Mr. Blunt's credibility was never relied on because no statement he made was relied on except to the extent it led to other evidence which was verified.
That is exactly what I'm saying, Your Honor.
Yeah.
That's exactly what I'm saying.
And my point is, didn't the magistrate have the right to know, in assessing the quantum of evidence, whether it met the standard of probable cause, to know that Blunt was double dealing in this case? Didn't he have a right to know that? So I've seen a lot of warrants in my time, an awful lot of them over the years, both as a prosecutor, a defense attorney, trial judge. This warrant, these warrants, I should say, they have all the appearance of being sanitized.
Well, Judge Keenan, let me, if I can briefly, before my time expires, just say a couple of things. It cannot be the case that all credibility information has to go in because that would conflict with other precedent. It conflicts with Coakley. It conflicts with, for example, Mackenzie Goudet. One of the issues in that case was a witness testified there was a gun in a house. A co-conspirator gave an interview where he said there was no gun. And the police left out the fact that the co-conspirator had said that. And the defendant cried foul. And what this court said is that's for resolution at trial. That's kind of the inverse of this case. Like, to the extent the argument is, but it's possible that Daryl Blunt was lying, that would be a trial argument to attack the weight of the corroboration evidence.
Now, I understand the argument you're making, and I think you're right. We probably do disagree on some issues.
I appreciate that, Judge.
All right. Thank you very much, Your Honor. Mr. Young. Ms. Platt, you have some rebuttal?
Thank you, Your Honor. If I may, a few points in response. So if I may disagree with my friend, Mr. Young, he tried to distinguish Lull by saying that here the evidence was corroborated. And as I lay out in my reply brief, none of the evidence about Mr. Pulley was corroborated in the affidavit. And in footnote 3 of Lull, nothing that's not in the warrant affidavit can be used to uphold the warrant affidavit. Again, it's footnote 3 of Lull. In evaluating whether probable cause would have existed, this is a quote, if the omitted statements had been included, we consider only the information actually presented to the magistrate. So that's a quote again from footnote 3 of Lull. I would also note that Lull is not distinguishable. I think Mr. Young said that because here there's corroboration and in Lull there was not. I'm quoting from page 112 of Lull. Quote, before initiating the controlled buy, officers searched the informant and found no contraband on his person. I'm sorry, I've quoted the wrong thing. Sorry. The sheriff's office corroborated some of the informant's information prior to conducting the controlled buy. That's one quote. Lower on the page, it notes that during the drug buy in Lull, there was actually a telephone recording device being used. So that's corroboration of the drug buy because it was being recorded at the time. So there was lots of corroboration of the informant's information in Lull. And anyway, the fact that the informant stole the drug money still served to be information that the magistrate needed to have to himself or herself judge the informant's credibility for the reasons that I started my argument with. Again, if you look at the Lull decision, this is about the structural integrity of the warrant process. The magistrate judge in a case, and it's not, Mr. Young says that I think that all information needs to be presented to the magistrate. That's not my position. My position is that when the police know that an informant has lied to them, as in this case repeatedly, about the transaction about which he is informing on the subject of the warrant, that is obviously material information that needs to be disclosed. And so these are quotes from Lull as well. The trustworthiness of the confidential informant lies at the heart of the reliability determination, and so the relevance of this information should have been obvious to Investigator Welch. I think this goes to Judge Meyer's concern about how you determine recklessness as a matter of law. If it should have been obvious to the detective, that is recklessness as a matter of law that, to Judge Keenan's point, the court can find. As to the probable cause, no, recklessness, Your Honor, recklessness.
Should have been obvious as negligence.
Yes. Recklessness, you have to have actual knowledge of the risk that you might mislead.
Well, and so, Your Honor.
And then overlook that.
Well, and so if you look
at the standard you just announced is exactly what Judge Meyer said.
Your Honor, this is a quote from Lull. It's a quote from this court. And so if you look at Detective Howard's testimony, she said repeatedly that she knew that Daryl Blunt had made conflicting determinations, and she was choosing among them herself, and that was fine with her. So she did know that that's what she was doing, and the record is replete of usurping the magistrate's role with regard to credibility.
Except if you accept her explanation, she is not using Blunt's testimony substantively. She's using it as the gate to evidence. And with respect to, if you have a informant who gives you 10 pieces of fact, and the informant is correct on 4 of them and lies with respect to 6, basically she's saying, I went out and corroborated the 4, and that's all I'm using. I'm not relying on his credibility. I'm relying on the fact that I was able to get the evidence.
But Your Honor, that's not what she did here. That's not what she did here. She put the lies in the affidavit. She said that Pulley committed the robberies that she knew Blunt had committed. And she put in the affidavit that Pulley committed them and not that Blunt had committed them. And so, meanwhile, as to the probable cause determination, the district court in this case...
Through the phone calls.
And the district court in this case, at page 665 of the joint appendix, held that the phone calls and the Facebook information alone were insufficient to be probable cause as to Mr. Pulley. And I did not read the government's red brief to challenge that conclusion. I did hear Mr. Young I heard him challenge it today at oral argument. I did not read the red brief to challenge that conclusion. I understand that the court can affirm an appellee or affirm a district court on any ground, but I did not read the red brief to challenge that conclusion.
It's not nearly as misleading as you suggest when she says on October 12, 2017, Blunt Darrell was charged with the listed robberies committed on April 12, 2016, October 27, 2016, and July 29, 2017, and was arrested. And so the magistrate is told that the officer, the affiant, believes that he is in fact the robber. In fact, he's been charged with the crime. And then below it says, after she says he's been charged, he said he didn't do it. So it's clear from context that the affiant does not believe he's innocent.
But, Your Honor, I think the fact that he hid the gun in the jail cell and that she did not reveal that is, again, far worse than the buy money and law. It's egregious because it's hiding evidence of this crime in the jail cell. And if I may, Your Honor, the joint appendix site for Ben Schaaf's testimony about the clothing that I offered you earlier, it's joint appendix 557 and 58. Ben Schaaf said that he was taking notes about the jail calls and passing them on to the investigative team, which, again, under Blauvelt is sufficient for the collective knowledge doctrine. And Mr. Young cited Massenburg, which happens to have been my case. That was a warrantless Terry stop case, not a warrant case. So.
Okay, thank you, Ms.
Thank you, Your Honors. We would ask the court to reverse. We appreciate it.
Thank you.
All right, at this point, we would come down to greet counsel and shake hands. As you know, that's the tradition of the court, and we can't do that, but we do it virtually, extending our greetings to you and thanking you for your arguments. This is still a civilized process that we believe in, and I know you two believe in it too. Thank you very much for your arguments. We'll adjourn court sine die and then get back to you. Thanks.
Thank you, Your Honor.
Thank you, Your Honor.
This honorable court stand adjourned. Sine die. God save the United States and this honorable court.
Judges, I'm going to be moving you to the private conference room now.